Good morning, everyone. My name is Hewlin Allman, many different variations of that. Hewlin Allman, I'm the Permanent Secretary in the Office of the Attorney General, and I'd like to welcome you all here this morning. I first of all would like to acknowledge a number of persons. The Prime Minister is here. She will join us later. At that point, we will formally welcome her. But I also would wish to acknowledge the Honorable Chief Justice, also Sir David Simmons, former Chief Justice, the Attorney General of Barbados, the Honorable Dale Marshall, the Minister of State in the Attorney General's office, Minister Corey Lane, judges of the Criminal Division and the magistrates. I'd like to extend a warm welcome also to Madam Justice Ram Sumaya Hines from Trinidad and Tobago, the Commissioner of Police, the Superintendent of Prisons, the heads of departments, representatives of faith-based sectors, the Barbados Private Sector Association, ladies and gentlemen. I'd like to welcome you all to what is essentially a part 2 of the symposium that was held on April 5, 2023 at the Lloyd Erskine Sandifer Center. There are two objectives here today, the continuation, the part 2 of this. One is to complete the part 1 program with 2 presentations, and those presentations will be by Ms. Dr. Margaret Gill and by Madam Justice Hines. I trust that these presentations will evoke robust and fruitful discussion and the way forward for Barbados's criminal justice sector. In his opening remarks, the Attorney General put on the table the establishment of the Criminal Justice Sector Committee to monitor implementation of the initiatives and decisions and to constantly receive feedback from stakeholders. At this meeting, stakeholders will be brought to the table as necessary and issues discussed to settle what is needed to give effect to those decisions and what is needed to enable them to achieve our targets. I am aware that we are running late, about 15 minutes late, so I will make my remarks even more brief. But I'd like to wish everyone a productive day. Just 1 or 2 housekeeping matters that I think we should just go through. Even though we're late, we will still try to maintain the time allotted for the breaks, and wherever possible, seek to limit or to bring back into line the period for questions and answers. As you would see on your program, there will be a review of the part 1 of the symposium by Dr. Gill. There will be a presentation also by the Bar Association, and that is entitled The Value of Public Awareness and Education and its Potential Impact on Victims and Witnesses and Witness Care. Following the coffee break, there will be a presentation by Madam Justice Hines, and which will be followed by lunch. I think we can make up in the lunch period what time we would have lost. And in the afternoon, we will be looking at the next steps forward and the way forward, including discussions on the establishment of the Criminal Justice Committee. And finally, the last session after a small coffee break in the afternoon will be the wrap-up session and closing remarks. I believe that after each presentation, there will be a period for questions and answers. At this point, I'd like to turn the podium over to Dr. Gill, who will give a review of part 1. Again, I'd like to welcome you all this morning. Thank you.
Good morning to everyone. Okay. Just to give you an idea about how the rapporteurs, how we structured the summary, we identified the objectives that were presented at the end by the PS, and we summarized the structure of the strategy paper and made our interventions based on what was said in the discussions. We filled in gaps that were in the strategy paper on that. I won't go through the objectives in detail, but just to highlight frank and full discussion by the stakeholders, consider the recommendations and initiatives that need to come forward in order to treat the issues, and finally to establish mechanism in order to be able to do the things that you want to do. So the first item is just a rundown of the kinds of problems that were identified in the strategy paper and that also came up. I'm not going to go through reading through all of them because you can see them on the issue, but I do want to highlight the question of unaccountability. That created a tremendous amount of discussion in one part of the first day that had to do with both the conduct of the police as well as the conduct of lawyers. Some small discussion about the conduct of judges, the magistrates, justices, was also part of that discussion. In terms of a significant issue of problems was the lack of public trust, and this was a lack of trust not only in the system of justice, but also in specific aspects of the system. And I think we all aware of that. The issue of preponderance of conviction on confession evidence was a critical issue that came up that we also want to highlight. And deficits of goodwill were very clear, not only as expressions from various groups, but also as an evident element in the discussion. So what we did was identified all of the places in which the criminal justice system expressed itself, and we broke these down into the structures or institutions that are existing, the kinds of processes all the kinds of processes that we were able to hear coming out of the strategy paper and out of the discussion within those structures and institutions, all of the individual people who were located in those places, and we felt it necessary to separate the structures from the people in order for you to see clearly what it is you're talking about, and the policies. So the rest of the discussion breaks those items down. Office of Attorney General, the courts, the police service, the defense system, Office of DPP, the probation department, prison services were not identified. I don't remember, I don't think it was identified in the strategy paper, but it was something that came up in the discussion. The Forensic Sciences Center was also a major part of the discussion. The Criminal Justice Investigation Unit is something that was identified as a necessity. The Bar Association was also one of the main structures. The Juvenile Liaison Scheme came up as part of the discussion, and it is critical to highlight that. The government industrial schools didn't come up in the discussion, but given that the Juvenile Liaison Scheme came up, it was felt necessary that also be identified there. Community legal services is a critical part of the structured institutions that came up in the discussion, as well as the regional security system, which was mentioned, but it's clearly a part of the system that you are wanting to inform yourselves on. And community organizations, we actually added that this morning because we realized that we also had a gap in our structure for community organization. In terms of the processes, as far as we were able to see, given that structure that we identified from your discussion, evidencing, hearings, this is very schematic, so the sentencing, the information technology communication system, data processing and analysis was not identified as clearly as it ought to be, but it was implied in several of the discussions. Research and development was also implied. It was not stated, but it was implied in terms of the need to inform yourselves about whatever the issues are. Research and development as a continuing part of the process was also implied in the discussion. There was need for case progression processes to be made more clear and also more effective. The issues of victim care, witness care came up as part of the discussion, as well as the care of defendants and perpetrators, which came as contributions from the social work, particularly from the persons who spoke from the social work and NGO communities who were present. And the DPP made a very strong case that is important to put here, the care of officers of the court. And she was speaking about it in relation to the DPP officers going to the court, but it holds for lawyers and it holds for the defense persons as well as other officers of the court. Okay, so the people who are critical in all of these different processes are, as identified here, police, judges, magistrates, the victims, witnesses, the jurors, the prosecutors, lawyers, and legal assistants. We made a distinction between accused and perpetrators because we wanted to identify that prison is also an issue that is identified among the prison officers are identified as people who are parts of the criminal justice system. Social workers clearly made their case for the need for their involvement. So some of these things are reported as gaps, and some are actually people who are there already, but some reported as gaps that need out of the discussions that need to be highlighted. The justices of the peace, the minister responsible for crime prevention is a new one, and the general public as a set of people who are a set of interests who are critical to the system. The policies we identified as the legislation, the rules of procedure, which a lot of the discussion happened around what was missing in terms of the existence of adequate rules of procedure. Education policies in relation not only to what the bar does, what the criminal justice system constitutes, what the rights of individuals are in facing the criminal justice system, as well as issues that are more software kinds of issues that have to, well, shouldn't really call it software because it's quite hard, but issues related to engagement of the community with each other in ways that would enable our criminal justice system not to be so heavily engaged in the lives of the public, of the community. And also the question of policies that influence the criminal justice system in Barbados having to do with the signed international conventions that are relevant to the system. Somebody has to give me a timer because I can't see Diane. 5 minutes, okay, thank you. The desires that were expressed, we felt it important to identify these for some of the issues that I will raise. There was a question of the common intent. Several people at the beginning identified that, and a common agenda. And I want to, this might not be part of my remit, but it's kind of impossible to get a common intent with a system with a completely conflicting interests, like the police and the perpetrator, or the defense lawyer and the DPP's office. So you would want to think some more on that issue. The common agenda is clearly it is possible, and it is identified in the first day's discussion as not present. Improved administration of and access to justice, upholding of the rule of law as a major desire of the community. I mean, the community that's represented in the first day, but also of the community in the country. Reduction of the court case backlog was a major issue on everybody's plate. Reduced crime because of its evident implications for not only the individuals who are involved, victims, as well as perpetrators, but also family members, the state. Eradication of corruption emerged as a major issue, and it was identified on the part of every agency that was represented. So the justices identified the need for more accountability and eradication of what was evidently perceived as corruption in terms of the way how defense handles its business, as well as from the defense lawyers in terms of what happens to individuals in their when they're facing the law courts. The question of increased security was a major issue, not just for the persons involved internally in the justice system, but also for the country as a whole, because of the fallout from a justice system that needs to be far more workable than it is, creates problems for the country in terms of development, etc. It was identified, particularly by Justice Birch, that there have been things that have been done, successes that we could point to. The AG also mentioned some of them. And this has to do with the fact that a number of personnel increases have been made in terms of the numbers of people who need to staff the whole system. There has also, Justice Birch also pointed to the significant amount of training that has already happened, and that is a continuing part of the process. He identified that the terms and conditions of the Latimer House principles, adoption of those principles significantly improved the terms and conditions of justices. The question of technology has also been an issue. Barbados has been able, from your discussions, to have implemented technology use in satisfying the needs of the system. Evidently, there's significantly much more to be done in that area. Education and public awareness, including initiatives by the Bar Association, were identified. And the question that I want to highlight is the issue of commitment that's identified as a success, particularly because of how the DPP talked about the capacity of her office to have delivered, and people working on Sundays, and every time she go in there, somebody's in there working. So that commitment from that end, the AG also identified the commitment shown by officers of the court in general who were able to advance issues during the pandemic. So the solutions and the way forward, we put these together in two ways. The first way highlights just the specific issues, all the issues that we identified coming down, and the second way structures these solutions according to and I'll show you, according to the structure that we identified, the structures and institutions, the people, the problems, etc. So partnerships, the need for partnerships, the need for technology, information integration, data analysis. So these are evident from what we've said before, identified before. Training and career support. The issue of career support is being a significant issue because of the significant amount of times people identified that young justices are not attracted to the system, and the evident shortage of defense lawyers. The redistribution of some roles, including incorporation of justices of the peace and more social workers. Okay. So this is the last part of the solutions in that general format, enabling goodwill, including education and information sharing, developing and harmonizing relevant administrative rules and guidelines, and in particular, this legislation was mentioned by more than one person, WR 75, paragraph 15, section 18.2, etc. Examining the feasibility of judge-alone trials, we identified that solution. We cannot try our way out of the backlog. It seemed particularly significant to us as the rapporteurs, as a solution, since it's offered as a solution, or it's implied as a solution. That was a significant point that we wanted to highlight. And mediation by trained community actors, including use of social workers in the judicial system. So this, I'm not going to go through this one, because what it does is just organizes those problems according to the structures, institutions, as you can see there, according to the processes. These are all going to be available, because this summary is an executive summary of the discussion that will be attached to the report. So the report will carry a fuller, obviously a fuller aspect, but these are available in case you wanted to have your discussions in the afternoon around specific structures of thing rather than just a wide discussion. These are available for you. Facilitating guilty plea case expedition was a major issue that came out. Having a sentencing rule book. The use of transcribers, recordings, the right to privacy, and affidavit protection in police recording, not just in the court recorders, but having recorders for the police. This is clear. Mediation, increased use of social workers, justice of the peace, community service organizations, NGOs, FBOs, or whatever, however we talk about them. The engagement of all actors in short and medium-term planning, which may speak to the committee that the PS identified earlier, that overarching committee. Policies, the rationalization of existing legislation, 8 pieces that are now spread across multiple enactments, and the UK PACE, it was offered as a good model to help us to do that for Barbados. New legislation for new forms of crime, the repeal of antiquated legislation, revisiting that as we said before, and identifying, establishing rules of procedure more effectively, more clearly. That was it? Yes, thank you very much.
We'd like to thank Dr. Gill for her summary of part 1 of this symposium. And without further ado, I will now call the presenter from the Bar Association for their presentation.
Good morning to everyone. So while, oh, there we are, great. So We are grateful to be here, and I believe reforming the criminal justice system is something that has occupied the members at the Barbados Bar Association, I believe. Andrew would probably tell me decades. Yeah, it's probably in double digits. And we were asked to speak on the value of public awareness and education and its potential impact on victim and witness care. Forgive me. I'm not a digital native. I have to get a passport. So you'll see me with paper and you'll see me with the technology. This is the language, first language for my daughter's generation, but this is my second language. Okay, so I have my backup. Oh, there we go. So apologies in advance if I press the wrong thing. Let me just go see. Great, wonderful. So the Barbados Bar Association, we've prepared a full paper. We do not intend to go through the full paper today, but just for completeness, I'll just let you know the contents of the paper, which includes, first of all, the introduction, a definition of witnesses, definition of victims, the Commonwealth Secretariat best practices on the guideline for victims, the current situation in Barbados and identifying what forms of support and care is required, and a comparison of victim and witness programs across the Commonwealth, 2 examples in the Caribbean and 4 examples outside of the Caribbean. And then we concluded with proposals, challenges in the criminal justice system with providing care for witnesses and victims, and the value of public awareness and what perhaps we could do. So just by way of introduction, I would want to say, I would, of course, please allow me to adopt the protocols having been established. Thank you. And secondly, I speak as president of the Barbados Bar Association, but I'm also careful to say I'm not myself a criminal law practitioner, but we have a good representation here from the bar. And we've taken the time to really ask our members their views. We've constantly asking them, and they are not shy to let us know of their challenges. And so therefore, I don't speak in abstract terms. This is based on information, surveys which we have conducted, reports that we have compiled, etc. Now, typically, attorneys would work primarily for the accused. And so therefore, I'd love to be able to know, among us stakeholders here today, the organizations or persons who routinely work with victims or accused. By a show of hands, are there any organizations here that routinely work with victims or accused? Anyone? I see one hand go up. Yes, no? 2? Okay. So many of us then, we are not interfacing with victims or witnesses. Well, certainly I believe the time has come for a formal recognition of the rights of witnesses and the rights of victims. And perhaps there's a lot of work we could do even before we have the legislative framework in place. Now, we are on the same page. We do want an effective, fair criminal justice system. I liken it to machinery. We want it to be a mechanism that functions. And you'll see that, that symbol that we have there. We are the stakeholders. We have our proposals, this criminal justice system. We want it to function and to work. Now, just very quickly to lay a foundation, the UN definition on witnesses. They have stated that witnesses are the foundation of a well-functioning criminal justice system. So that's why we have the infograph there. And because as their cooperation with law enforcement and judicial authorities is essential in prosecuting crimes successfully, protecting witnesses from intimidation or physical threats from crimes suspects, protecting witnesses from intimidation or physical threats from crime suspects is therefore a requirement to uphold the rule of law. On the definition of a victim, the United Nations Declaration on Basic Principles of Justice for Victims of Crime and Abuse of Power defines victims as persons who have suffered harm, including physical or mental injury, emotional suffering, economic loss, or substantial impairment of their fundamental rights through acts or omissions in violation of criminal laws operative in domestic legislation. So that gives us an idea of who's a witness and who's a victim. Very often, I believe, we would know that there's a blurring of the lines, and sometimes, and very often, the accused may also be a witness. The accused may be a victim. The victim may be a witness. So, first of all, let's look at the current situation in Barbados. There's some levels of protection, very limited. We do have domestic violence legislation by way of protection orders. We have some counseling and support systems which exist. I encountered one in my work, applying for a mental health application dealing with the Black Rock Police Station. I have to say it was a very positive outcome. I'm grateful to the officers there. There are protections afforded, of course, to minors embedded in different legislation, but generally these victims are vulnerable. There's no one matrix by which we can say, okay, this is how victims are protected, this is how witnesses are protected. So we do not seem to have a level of protection across the board. And from inquiries made from senior persons in the criminal justice system, there are one or two NGOs, I believe, that provide some support, but we weren't able to identify specifically. So therefore, our work is cut out for us. Now, we examined quickly some jurisdictions further in the paper, but before we get to that, we want to look basically at identifying these forms of support and care. Now, for victims, and witnesses, they should be kept informed of the progress of prosecution in a timely manner. They should know what charges are laid, what the charges mean, especially for victims, the date and place of hearing for trial for witnesses as well, outcomes of bail proceedings, outcomes of proceedings and appeal proceedings, and victims should have the prosecution process explained to them. This information is taken from the research that we have undertaken. In some jurisdictions, there's additional support because, of course, being either a victim or a witness, for many people, is a traumatic experience. And then to compound it, the engagement with the criminal justice system can add further anxieties. So in some jurisdictions, we find that they have emotional support to help witnesses. They provide information on the court process. They show witnesses the courtroom before the trial. They give them support on the day of trial, at the verdict, at sentencing. They help them with any additional extra support, including if they have to relocate to a safe place or refer them to a partner organization. So in the Caribbean, from the research we conducted, and if anyone knows about the St. Kitts model, I'd love to hear some more about it. I wasn't able to get all the information I would like, but I did get this information from an attorney in St. Kitts and Nevis, and they indicated to me that they do have a Justice Protection Act, which provides some level of protection for witnesses. That information is not readily available online. Jamaica, however, has a slightly different model. I did not see a specific piece of legislation. However, for Jamaica, very interesting, they have a well-developed web page, which is actually an arm of the Ministry of Justice. They have a Victim Services Division, VSD, which was previously known as the Victim Support Unit. They have a stated mission, and that is committed to act in the best interests of victims by actively supporting them, identifying their needs, and optimizing their participation in the justice system. The division assists victims of crime to manage and cope with the emotional trauma associated with and caused by crime. So if you go on to the Ministry of Justice unit, you will see a tab marked Victim Services Division, and these are the The services provided. They actually provide face-to-face telephone and e-counseling, crisis intervention, victim rights advocacy, public education, development of actually have a victim-sensitive special intervention programs. They have network, promotions, technical services, policy development and implementation, and they also have volunteer mobilization. By that, I understand it to mean that if you are an NGO, if you are someone who provides either counseling or support for victims as either in full or as a part of what your services are, you can coordinate with the Ministry of Justice and be a part of, well, I would imagine after full due diligence, etc., be a part of their referral program. I found this interesting because it meant that even I could not identify a legislative framework, but you had a distinct provision for victims. Well, I'll go back one moment. This is for the Caribbean. I won't go through the jurisdictions that we had covered in the beginning, but if you do have time, you can look particularly Ireland. Ireland, the Ministry of Justice, has a very well laid out program for victims. For Canada, a little more complex. They actually have a full suite of legislation, including charter rights, etc. But you can, and then when I checked to UK, I also saw that a lot of the victim units were an adjunct to the particular police, the police service in that particular county. So there are a number of models that we could look at, even before we get to the legislative framework. So proposals for public awareness, the method of communication. I believe we could start as early as today. I believe that even though we don't have a structured program, I believe that we could provide good information to victims and witnesses from perhaps an online platform. As we say here, typically the public will not engage in such a topic unless they are themselves a victim or a witness. And in jurisdictions with structured programs, there are legislative provisions to protect both victims and witnesses. And as such, their educational programs focus on educating them on the legislation. I believe at this stage, I'm sure that there are organizations, including the bar we could start, that have either an existing website or something online, and we work together as stakeholders to provide a toolkit, digital flyers, basic information. If you are a victim, then, and some kind of information, because typically, if someone is traumatized as a witness or a victim, they're going to want to seek that information when they can, probably quietly, privately, online, before they gather the courage to be able to step forward. So if we are looking to begin to educate the public, I think that we can start by having good information posted across the stakeholders, and so that we can begin to let the public know that not only they have basic rights, but there are persons to whom they can turn. So the way forward, there are proposals. We can, as I said, information can be readily available. Even at the time of investigation or reporting of a crime, we could perhaps find a way to have information available as early as that, so that witnesses come in and are a part of the system. They are identified early. Information needs to be available in a format so the public can access it 24/7, multiple times if the need arises. So online and digital is probably best. Toolkits, how-to guidebooks, booklets, all electronic. Websites or web pages, we can, rather than creating a website, which has its attendant costs, we can look at the existing ministries' websites or existing organizational websites and create a web page which has some support information. That is until we have a legislative framework as is suggested in the national reform document. So the question is, I put it out to us, we the stakeholders, is there an organization here that would be willing to post any such information as an adjunct to what you currently do as a stakeholder? Anyone? Bar has its hand up. Okay, thank you. Can I get the name of your organization, please? Men's Support. Okay. So you have already existing, I would imagine, some means by which this information either can be posted or disseminated. Yes, great. And so, Sarah, as I call your name, can we work to develop? Yes, we can. Oh, she has information already. So it seems as if it's not so difficult a hurdle, at least to start the recognition of witness and victims' rights. And that's something that we can do right away. The framers of the legislation could speak to us in due course about what that legislation will look like.
Yeah.
Yes.
In addition,
Yes, Minister Abrams.
In addition, we can circulate that information to you, for you, through JS and Public Affairs, and we can just keep it in rotation. We can also link it to the AG's office and the Ministry of Information. So we can, once you have the information, we can get it out there and keep it out there for you.
That's very good. Thank you. And so we have the way forward in action right now as we speak. So we are stepping out into part 2 of our symposium, having identified the issues within the system. There is a way forward. So we go back to the infographic. We, the stakeholders, we're making our proposals today, and it's a part of a wider machinery of what we can perhaps do as stakeholders. Now, I want to put the witness and victims presentation in context. And when I showed you the very first slide with the paper, there is a little section saying context. And context is very, very important because we have to, one of the things that we identify that witnesses and victims require is information. When we deal with clients who have, I might be dealing with a client for another form of service, legal service, but it intersects or interfaces with a criminal matter. Typically, I find as an attorney, there's a lot of confusion. They don't know when the next court date is. They don't know when the adjourned date is. They didn't know which court. They went down to the wrong court. And if I am not actually involved in the matter, I would have to then find out whether there is an attorney acting that I could find out about that information. So even as we look to provide that facility for witnesses and victims, we have to look quickly at the context, because every case in the justice system involves people. The accused, the witnesses, the victims, the minors, the young offenders, and we all know justice delayed. So the first thing is that we have to understand what really would be the strategic objective and how the witness and victim program will fall within that. And even as attorneys at law, we would have indicated at part 1 of the symposium, we feel the effects of the delay. We know there is delay. The Honorable Attorney General referenced 94 murder cases, the oldest of which 2007. 287 are firearms cases, oldest of which is 2003. Am I correct, Honorable Attorney General? I believe so, on the last occasion. So we have cases that are 20 years in the system, and each one of those cases represents people, witnesses, victims, etc. So we need to know the age analysis of these matters. If we talk about in the document, which the national strategy which was presented, a backlog of 1,700 in the High Court, cases in the High Court. And I don't know if this is correct. It said 16,000? You sure 16,000 in the Magistrates Court. Okay. But the issue is that the causes of delay are not static. So therefore, what caused delay 20 years ago may not be what caused delay now. We don't know. We have to see the data. And that's why we are asking for, within the national strategy, a distinct policy, national strategy on reporting, so that we know and understand where in the machinery the constant delays are occurring. For example, across the Commonwealth, courts are the primary source of data. When we did our research, they publish annual reviews. And I appreciate much of this is plugged into a computer system, and that allows the court to be able to report annually. So we propose that there are annual reviews that assist us, the stakeholders, including attorneys at law. We would need to know, in the kinds of reporting, how many new cases per year, the disposition of cases, current caseload year on year, so how many more from last year, the pending caseload, compliance with timelines, that's when the criminal procedural rules are implemented. What types of cases in a broad way? Because we speak about implementing a sexual offenses court or implementing a serious crimes court, but will that really reduce the backlog? We don't know how many of those 16,000 will be streamlined. We don't know steadily what we're steadily working towards. And the backlog and all of that is important because victims and witnesses don't know where to look. There's no list, there's nothing that assists them, there's nothing to help them when they want to be able to attend the criminal case or to know what is going on with the criminal matter. We need a clear national strategy where we are juggling all three in the air. We're reducing the backlog of outstanding cases while maintaining the current caseloads and doing the course correction to ensure no further, or at least reduce further backlogs as we proceed. So we welcome the initiatives in the national strategy. We welcome criminal procedural rules that would establish consistency and and uniformity in handling of management of cases. For example, pretrial disclosure, you say, okay, it has to be done within 6 months of a person being charged, so it allows the machinery to turn. We agree with amending the mode of trial for certain offenses so that we can reduce delay. Certain offenses then, which now go to High Court, can be dealt with summarily. Mechanisms for young offenders. How many young offenders are in the system? We do not know. Will that assist in mitigating the reduction of the backlog? We welcome the initiatives relating to investigation and trials, but how do we approach matters where we spoke about the forensics, our colleagues spoke about the forensics unit. If the forensics unit is unable to provide that material, and it's not likely, what would be our approach? So we do have some concern that even as we put initiatives, we implement initiatives, we have to be careful that we're not implementing initiatives but not also dealing with the wheels turning, because then I'm just putting new features, brand new features. I drive an old truck, so I'll be putting brand new features on an old truck, but the wheels turn very slowly. So that doesn't assist me if I have on a body kit and all kind of pretty bells and whistles, and then when I turn the key, I'm not going forward. We need to keep all three wheels turning. And the initiatives must be well suited to our context so that we're not implementing legislative reform to create more structures when we already have scarce resources. Simple questions as well. There are 7 courts, criminal courts. Is that correct, Andrew? 7 criminal courts, no? 7? Eight? 7? Okay. Are they all sufficiently supported and resourced to work a full day, every day of the week? Do we need to resource these courts? So in other words, just do the math. If there are 1,700 high court cases, how many do we need to do per year to reduce that backlog in 3 years? If there are 16,000 magistrate court cases backlogged, how many of these do we need to work on in 3 years? Just the simple math of it. And if we then say that the 7 courts must fully function every single day of the week, 5 days a week, marshals, clerks, cat reporters, judges, magistrates, all fully supported, then you have to manage change. And of course, the question was asked, are there enough attorneys at the criminal law bar? Asked and answered. The Bar Association assessed our members in a survey, and in conducting that survey, they have told us the inordinate delays, length of time from being charged to disposal, the inconsistency from case to case. These are the issues that they encounter, and they have said that we find this area of law unattractive. I spoke with Sarah, and I believe there are ways that we can make this area of law far more attractive. But we have taken the time to produce a report from the Barbados Bar Association, which we have shared with the Honorable Attorney General and the Honorable Chief Justice. It's 150 pages long. I do have a copy here. I'm sure nobody wants to see it today, but it's here. And we have invited discussion with the Honorable Attorney General and the Honorable Chief Justice on that report. So to close, I would want to say, this is a national effort. And we, the stakeholders, are part of a much larger picture. It's a matter of public confidence. It's a matter of public trust in the justice system. It's a matter of international perception, not only of the criminal justice system and the law, which I love, but Barbados' legal system in general. So we, the Barbados Bar Association, we have our council members here today. This council, this president, we are committed to saying to our members, this is a national effort. Fall in line. What do I mean by that? If there's a backlog, 1,700 in High Court, 16,000 in Magistrates Court cases, and we have to double up, we have to work harder to reduce the backlog while maintaining the current caseload. And a policy decision is taken to say fewer adjournments will be granted, trials will proceed on the date set, so please try and get everything together. Cases will be heard on dates fixed, timelines will be set by the court, or when we have our criminal procedure rules, those will dictate the timelines and those must be complied with. Then we, the members of the Barbados Bar Association, have to play our part. So just in closing, I'm just sharing, as we had the infographic of the wheels turning, the definition of the components of the rule of law. I was actually looking for one by a Caribbean jurist, but I did find this one by Lord Nuremberger. First, the laws must be freely accessible. That means as available and as understandable as possible. So even as we do our legislative frameworks, the public needs to be able to understand what it is that we're trying to achieve. Secondly, they must enforce law and order in an effective way while ensuring due process. And they must accord citizens with their fundamental rights against the state, and they must regulate relationships between citizens in a just way. And thirdly, the laws must be enforceable unless a right to due process in criminal proceedings, a right to protection against abuses or excesses of the state, or a right against another citizen is enforceable. It might as well not exist. Thank you. Pilgrim to join me.
To join you? Okay, right, to take the questions.
Yeah.
Yeah, okay. We'd like to thank for this presentation. At this point in time, we will take some questions for the next 10, 15 minutes, but we'd also like to invite the past president, Andrew Pilgrim, Mr. Andrew Pilgrim, to join us here. There are a series of mics that you can always line up and make your present your questions. We'll start the questions now. Thank you.
I just wanted to add briefly to what Kay was saying, that part of the problem is that none of us really specifically take responsibility for victims or witnesses, in that from time to time we will have a brief, what we would call a watching brief on behalf of an alleged victim of crime, and we therefore get involved at that level. The police are required a lot of the time to take on the responsibility of keeping witnesses up to date with what is going on with the case. Same token, the DPP's office required to keep in contact with people, but there needs to be a resource or a number or something that any person who says, look, I am a victim of crime, I can call this number. And it becomes extremely challenging. I think the police will bear me out in this, that there are circumstances where a victim of crime, and quite often specifically domestic violence type crime, requires more than just knowing a date. So that, by way of an example, a lady called me last week and said, she's being abused by my client. Can I help her? And she says the approach of the particular policeman, I'm very careful to say this because I know a lot of police officers are very sensitive to this type of situation. The particular police officer said, you go on and get involved with such and such, well, you should know what's going on. You know who he is and what he give. But the point is that person will need support, and they will need to feel that they got a number I could call to find out, to let them know that he is still causing me a problem whilst this case is pending. When next is he going to court, so I can be there and say to a magistrate who can help me and defend me and protect me. And the fact that it is dispersed over all these agencies with none of us having a clear responsibility for the victim comes back to the slogan of, what is it, no witness, no justice, which was, you know, a real sore point for us some years ago, and we have really done nothing to move it to a level where we have to hope that Ms. Renee will make an effort to protect a witness or give them certain instructions. I heard her doing that very much so in her court very recently. But the point is, we need to know whose job is this, who is out there ensuring. I do a case with Mr. Seal, Director of Public Prosecutions acting, and we will agree that we make sure the witnesses know what we're doing and we can get them in the Zoom hearing if we're doing a Zoom. We know what we have to do, but whose job it is. And I think part of the problem is that sometimes people in these circumstances are slipping through the cracks. Thank you.
Before we continue, I'd like to acknowledge the presence of the Prime Minister. I'd also like to acknowledge the presence of Ministers Abrams and Humphrey. Yes, I didn't have my glasses on, so I'm sorry about that. But if there are any questions,
I can't believe they don't have any questions. So David, yes, please. You had a comment? Yes. Yeah.
Good morning, everyone. Thank you very much. I didn't get a chance to speak last time, but I wish to take an early opportunity to appraise you of some of the work being done by the Law Reform Commission that may be relevant to this symposium. Now, in perusing I won't keep you long, I promise that. In perusing the strategy of Mrs. Abrams and Ms. McDowell, I have noted that a number of their suggestions were identified by the Judicial Council way back in 2007 and appear 102 recommendations appear as Appendix 1 to the report of Judicial Council 2007. Carlitos Beckles is here, and he helped to prepare that. So that there's a large measure of agreement as to what needs to be done to reform the system and its interlocking processes. Today, I wish to just mention some of the strategies enunciated in the reform strategy, and in particular, our work. Let us turn first to the criminal procedure rules that were mentioned by Kay. 2 years ago, the Commission offered the former Chief Justice a suggestion that we should do something that is not usual for law reform commissions. Law reform commissions do not, as a rule, deal with the development of rules and procedure. They deal with substantive law. But we thought that it was so critical to getting some action and moving the whole process along at a faster rate that we should take the initiative. There was a hiatus, and COVID intervened, but I am pleased to tell you that we are currently, all like today, developing new criminal procedure rules. We looked at the rules in Trinidad and Tobago around 2016, the rules in the OECS about the same time, and we were minded to stare closely to the rules of the OECS until April the 5th. When Sarah explained to us that now that the OECS rules have been implemented, a number of difficulties have arisen. And it would perhaps be unwise for us, with knowledge of those deficiencies or defects, to follow the OECS rules. They have, Sarah and Ms. McDowell, they have developed new rules for Belize, which have taken account of the shortcomings in the OECS rules. And the Law Reform Commission took the decision at our most recent meeting that we would follow the Belizean model, and the State Council, who is assigned to the Commission, is, I better say, has completed a first draft of new criminal procedure rules. We will share them with Sarah and Ms. McDowell. We will share them with the Bar Association, with the DPP's office, with the judiciary and the magistracy and the police before we recommend implementation. There has to be consultation. That is our mantra. Whenever we are doing new legislation, we will consult with the stakeholders affected rather than rush it upon you. So I would think by the end of June, those rules will be available for consultation. We may have a working session of all the relevant interests so that we can bring everybody together. You would have had them for about a month, and we will have, let us say, a one-day session somewhere to go through them. So that's where we are with the rules. This morning, the bar focused on doing more for witnesses and victims of crime. One of the ways in which we can attack the deficiencies in those particular areas is by updating the Evidence Act. And we have embarked upon revising, perhaps not revising, developing completely new legislation. It will be called something along the lines, we haven't settled, but something along the lines of Evidence Miscellaneous Provisions Bill. And it will cover about 7 things. Let me just identify them for you. Admissibility of computer evidence and foreign documents, receiving evidence in legal proceedings via technology, for example, by video and audio technology, measures for assisting witnesses, for example, the use of screens to shield certain witnesses from observation by the accused. We will look at receiving evidence from a witness in a foreign country, pay particular regard to evidence in sexual offenses. We will look at making witness anonymity orders so that we can protect the identity of certain witnesses. And very importantly, this bill that we are proposing will cover in a holistic way DNA evidence, including obtaining bodily substances from victims of crime. What the new bill will seek to do is to ensure that evidentiary provisions are kept under continuous review to ensure that we have a contemporary and effective approach to evidence. And the precedents which we are using were approved a long time ago by the Attorneys General of small Commonwealth jurisdictions at their meeting in St. Vincent, I think it was 2002, November. That bill has to be drafted, and we will do the drafting in-house. Then we will have a consultation paper to go along with it, and again, it will be sent to the relevant stakeholders, such as I identified earlier, at the end of which there will be a policy paper that will contain drafting instructions, because the CPC's department has very strict rules about the adoption of model legislation. They say in writing that model legislation does not constitute drafting instructions. So we have, anyhow, we found a way to deal with that. Couple of things from last time. There was mention of the use of ADR in magistrates' courts. I think the PM mentioned it in her address, and Sarah Abrams. But I wish to say that since 1998, the Penal System Reform Act in Part 3, Sections 20 to 32, has made provision for mediation to be used in the magistrates' courts. I don't know if the magistrates use it. When I brought it, it was to respond to a number of problems among young children in school, fighting, quarreling, slapping up one another's head and so on. And rather than criminalize them, we thought that we should introduce this in the magistrate's court. Professor Fiaggio, in his book on ADR, welcomed the legislation, but was critical of the fact that we had it limited to people, I think, under 18. And we just need to do a little amendment and expand it. The cohort at that time that we were looking at was between 14 and 18. It may now be 17 to 25. The Criminal Justice Research Unit should be able to tell you that. And you can do the amendment to expand the use of ADR, but counsel and the courts have to take the lead in determining when a case is fit for ADR and then put the processes in place. Similarly, the Penal System Reform Act provided in sections 9 to 12 for the establishment of attendance centers and gave the courts the ability to make attendance center orders. Rules were drafted to support the operation of attendance centers. And the rules were published as statutory instrument SI 1999, number 98. If you try to Google it, you'll only find 2 pages. Only find 2 pages on Parliament's website. I don't know what has happened to it, but part of it has dropped off. But if you go to the essays, the volume of the essays for 1999, you should see the attendance center rules there. The purpose of the attendance center, I hear all kinds of things being proposed, but what we were aiming at then, and I think may still be relevant, is to deal with young offenders who are really in need of discipline and training, and many of whom also have deficiencies in literacy and numeracy. And the idea was that when the courts, you can expand it to the juvenile liaison system, when the courts came across one of these types of individual, instead of giving them a conviction, you would try to impact their leisure time by saying that you must attend so many sessions at a particular place on in those days we were saying Saturday afternoon, so you can't go to theater at the Globe. And the attendance center would be staffed by people who were disciplinarians. For example, when it came out, I had a call from a former police officer, glorifying in the name Lion Man, who said to me, I want one of them jobs to be able to instill some discipline in some of these young people. You turn up and you are given instruction in a particular environment that brings home to you the necessity for good behavior and discipline. That legislation is there. The attendance centers have never been brought in. I brought in everything else before I left. I went to CJ, except that. But you know what held it up? The Insurance Corporation of Barbados. There was a hassle. I had a, what you call him, a special advisor, Mr. Hallam King, former headmaster of Courage and Parry. And he spent a lot of time trying to get the Insurance Corporation of Barbados to settle a rate for insurance. They said that because we were going to use Princess Margaret School, St. Michael's School, the one in St. Thomas, Leicester Vaughan, and Alexandra, just a couple of rooms, we had to insure that those activities, and they could not give us a figure. And I left and went down to Corey Street, and for all these years since 2002, the only part of the Penal System Reform Act that has not been ever brought in is that part dealing with attendance centers. Minister, you have a chance now to make sure you do it. Final point I wish to make is in relation to the bar's proposal about being familiar with international conventions. And I wish to say, this is something that has given me some occasion for concern. I was in Parliament for 25 years. During those 25 years, I cannot ever recall a treaty being laid in Parliament. I recall when we joined the regional security system, that treaty was appended as a schedule to the parent legislation, and similarly with the CCJ. But Barbados has signed a large number of treaties and conventions over time, which the CCJ, as you all know, has said even if they're unincorporated and not domesticated in local legislation, still create a legitimate expectation, so it gives you a cause of action. Any of you ever seen a treaty? No. I made a proposal to the Constitution Review Commission that in future, the new Constitution should say that a treaty must be laid on the table of Parliament for 90 days and be posted on a website that is accessible by the public, but not be shrouded in mystery. If it is going to create rights, then the citizens of Barbados have a right also to know what that treaty says. Thank you very much.
We'd like to thank Sir David for his submission. Are there any questions or clarifications that are required? Yes, I see in the back.
Hi, good morning. Just a question about the elderly. What provisions are being made for elderly victim support? Because as an aging population, I guess eventually there may be a larger number of victims past a particular age. Are y'all looking at that as well?
There is no specific provision or, other than the Mental Health Act itself, I cannot, if anyone can assist me, I'm not sure whether there are any provisions specific provisions are in respect of your question. But they are a vulnerable group, like minors, and it underscores why the criminal justice system, in general, there's need for formal recognition of witnesses and victims as a right, on a whole. If anyone wishes to add to that, please let me know, but I'm not aware. Yes, sir. Yes, Sarah. Yes, good.
Good morning, everybody. My name is Sarah Abraham, the Criminal Justice Advisor. In terms of elderly, just like children and victims of sexual assault, I would suggest they're vulnerable, and therefore all of the excellent legislative provisions that are being brought in respect of vulnerable witnesses would apply to the elderly. One extra provision which I was speaking to Sir Elliot Motley about this morning was about actually recording the evidence of vulnerable witnesses and then playing it in court. That would be really helpful for both elderly witnesses and victims in terms of ensuring that the jury heard and could see the emotional reactions when they were a victim of crime, and also obviously being older, unfortunately, people die before they get to trial, and therefore another reason why that provision would make a big difference for vulnerable witnesses. Can I just also, while I'm here, on the issue of witnesses and victim care, what I would suggest is that the Witness and Victim Care Unit does come under the police, because they are the only ones who would always have the information in relation to where a case was in terms of investigation, charging in the magistrates' court, in the DPP's office. We have helped St Vincent and the Grenadines set up a victim and witness care unit because they have a national prosecution service that has come under the DPP's office. But I think in Barbados, and I can't see the Commissioner, I know he's here somewhere, I think actually it would be best coming under the police, the Witness and Victim Care Unit. But obviously it's a matter for you about whether you think that's the best place.
And of course, Sarah, with respect to recordings, you would know we would have concerns with respect to the recordings and how they're done, et cetera, et cetera, et cetera. But if we work together as stakeholders, we can address those concerns and have those embedded in legislation. Thank you.
Hi, I see Mr. Clark, Assistant Commissioner, coming. And
you didn't see the judge down here, everything?
Sorry?
You didn't see.
Oh, sorry. I beg your pardon. You're not so diminutive that you should be missed. But I just want to remind also all persons coming forward to identify themselves before they speak. Thank you. His Lordship, Justice Graves.
Sorry about that, Mr. Clark. Good morning, everyone. I'm usually a tail ender. I like to bat. Come near to the end of the innings. So I'm a tail ender that can bat. But today I'm going to come a little earlier, just to refer to a few recommendations that I wish to make, so that I wouldn't have to say anything more for the rest of the day. On the last occasion we were here, there was a paper presented by Mr. Justice Birch, which dealt with the issue of judge-alone trials. And we didn't have any questions and so on following that up. But it's an area that I'm particularly interested in. And I wish to make the following suggestion. I know since the COVID came, there has been a cry around the Caribbean and Barbados, for example, for judge-alone trials at the Supreme Court level. I have made my position clear in other circles about the type of judge-alone trial regime I would like to see if it happens at the Supreme Court level. I'm not going to refer to that now. I am going to refer to an alternative system that I think might be better suited to us than the judge-alone types of trials at the High Court that we hear about from the different jurisdictions. I think the Prime Minister, I think, touched a bit on this last time, and I wish to add my support to this. I would like to see in Barbados an extension of the magistrate's jurisdiction so that they try a lot of the cases, offenses that are now being tried in the magistrate's court. I think Sir David in the High Court, I think Sir David also just touched on that a bit. I would also like to see an increase in the numbers of magistrates in order to accommodate this process. And thirdly, I would like to see an elevation in the status of magistrates to accommodate this situation. So I'll start with the increase of the magistrate's jurisdiction. There are a number of offenses, and I hope the Law Reform Commission is really studying this. I think Sir David just touched on it, that, in my opinion, have no right being tried in the Supreme Court before a judge and a jury. Causing death by dangerous driving, indecent assault, sexual offenses as a whole, not including penetration, for example. I think in Bermuda, for example, a magistrate has his jurisdiction to try sexual offenses, certain types of sexual offenses, and can impose a sentence of up to 10 years. So I'm expecting to see, if my recommendation is accepted, that we would increase the penalty level for our magistrates. Drug cases. Modern jurisdictions know that drug cases are among the most corrupting type of cases that you can have. And they're really poorly fit for trial by juries. Very often you will get absurd verdicts. If you remember many years ago in Bahamas, when the airplanes were landing on the highways and so on, as that was a major transit point for drugs. Yet you could hardly obtain criminal convictions. If I recall correctly, they changed their laws to allow for drug cases, regardless to the quantity, to be tried by judge alone. I think the proper place for it is at the magistrate's level. At this point, magistrates can impose sentences, I think, up to 5 years in Barbados, or 7 years, right? The Supreme Court doesn't do much better than that in a lot of cases. They can impose fines up to, I think, $100,000 or thereabouts, or 3 times the market value, something like that. So if a penalty like that is increased up to maybe 10 years or whatever the case is, I see no harm with magistrates trying those types of cases. A recent one was this one escape from custody. Ridiculous that you would select a jury to try cases like that. A recent one I noticed was this problem we have with bounce checks, forgeries, carrying counterfeit money, and that kind of stuff. All of those, in my view, are properly triable by magistrates. Even the grievous bodily harm and wounding cases, particularly when persons are charged for wounding with intent. The dilemma we have here is that those cases have to wind up in the Supreme Court. And very often what happens there is that the person might plead not guilty to wounding with intent, and he gets a sentence for unlawful wounding or GBH. Now that should have been able to be accommodated at the magistrate's court. And in today's world, you're not locking up people anymore for wounding and GBH cases when a settlement might be agreed or promoted between victim and assailant. Now, then there are some types of burglaries and robberies that I think can be tried down there. Firearm cases, in my view. The possession of firearm and ammunition, I always thought it was a mistake to push everything up to the Supreme Court. I think much of it can go back to the magistrate's court level. Possession of a firearm when, or 2 bullets or 3 bullets, in my view, makes no sense being tried by a judge and a jury at the Supreme Court. That can be handled down there. You give the magistrates the jurisdiction to apply the appropriate sentences and so on, and that might help to ease some of the pressure, expense, and wastage of time upstairs. It would be necessary, in my view, to increase the number of magistrates. My view is that it is cheaper, more practical, more productive to have more magistrates than to have more judges. Judges come with some peculiarities that magistrates may not come with. If we are going to do all of that, it means that we should increase or elevate, in my opinion, the status of magistrates. I'm going to start with the simplest part of that. A lot of jurisdictions now have been changing the name of magistrates to different types of names. In Jamaica, for example, they are now known as parish judges. In places like England, I think they're known as district judges. I tend to favor the name summary judge because that's what they are. The magistrate's court has always been a summary court. I see them as no less a judge than a judge of the Supreme Court. So my view is everybody should be called judges. You have what we used to call puisne judges, what we now call in Barbados high court judges. You have judges of the Court of Appeal, and you have judges of the CCJ. But why not have judges of the Magistrates Court, or the summary courts, as we should probably now call them, since they're going to be judges sitting alone, and call them summary judges. The reality is, just as has happened in the Supreme Court, in the Court of Appeal, and the High Court, is that people are going to drop the first part of the name anyhow, and everybody be called judges, but doing different functions. That's the first part of the reform of their status. I believe that creatures as important as magistrates, who do so much, who, for example, as the president of the bar now says, has 16,000 cases to clear up, while the Supreme Court just has over 1,000, should not be without proper constitutional recognition. They should be provided for in our Constitution in clear terms. And there need not have to go through, the regime need not have to be as cumbersome as it is for the riddance of a judge of the higher court. But we must be wise enough, bright enough, to be able to find a regime that makes sense so that our magistrates are protected under the Constitution or provided for under the Constitution.
Justice Grave, I appreciate your submission. We are a little bit pushed for time given the fact that we have had to, we will now be avoiding or ignoring the coffee break. I was wondering, in the afternoon, there is a session which deals with the wrap-up and the way forward, excuse me. I propose that we use that session to elaborate on the many different issues that we have, but I'll give you another 2 minutes so that you can surmise.
Yeah, because this is only recommendation 1 that I'm wrapping up.
Okay.
I have 14 of these.
You have 14. Okay.
Okay.
In that case.
So I'm going to wrap up this one for you.
Okay, thank you.
Yes, I'm going to wrap up this one for you. You broke my train of thought a little bit there. I'm getting old now, so you can't interrupt me so much now, like you used to one time. But this one, yes, going back to the constitutional protection, I think is very important. And I cannot see how we can have a new constitution without this in it. This, therefore, if you're going to be increasing the jurisdiction of the magistrates, and for both criminally and civilly, let me wrap up justice a little bit. If you're going to be doing that, you're going to be wanting to avoid the kind of situation we had in the seminal case, the classic case of Hines and the Queen. It's a case I never liked, the distinction it sought to draw there. You remember Hines and the Queen? The issue they had with the magistrates and the judges, the protection because of the great sentencing powers the magistrates were now going to have with the gun court and so on in Jamaica. So we'll be able to avoid that if my position is taken. I'm going to stop at that point and refresh to return with the other 13. Thank you.
Okay. Thank you very much, Justice Grave. As I previously said, we will not go to the coffee break. There are refreshments, but we would like you to, maybe 1 or 2 at a time, no more than that, to go out and avail yourself of it. But we will continue so that we can conclude this session, the morning session, and then go to lunch. And as such, I would like to thank, therefore, Mrs. Williams and Mr. Pilgrim for their contribution to this session. And I'd like to thank also Sir David for his seminal submission. Thank you. At this point, we will go directly to our next presentation, which will be given to us by Madam Justice Lisa Ramsummer Hines of Trinidad and Tobago. I got a little clip here that I actually took from her website, so I just want to introduce you to her. Justice Hines began her legal career in 2001 as a prosecutor in Jamaica. She returned to Trinidad and Tobago in 2004 to serve as prosecutor, registrar of the Industrial Court, a magistrate for 13 years. In 2017, she was elevated to the position of judge of the High Court, where she presides in the criminal division. Justice Hines had been involved in the UN Women's Project to develop and implement gender protocols for regional judiciaries. She had been a facilitator in several training sessions throughout the Caribbean in gender-sensitive adjudication and the use of the protocol. The protocol provides guidance to judicial officers to help them recognize and eliminate gender biases and to strive for gender equality in the adjudication process. One aspect of Justice Hines's CV was that she was a mother of 6, 2 humans and 4 canine. I think that would put it in perspective. We welcome Justice Hines.
Good morning, everyone. I wonder for a moment. I hear I have a very warped sense of humor, so forgive me if that is injected in this presentation. I wonder perhaps if the mass exodus from the room is because I'm the only Trinidadian in the room right now. I sincerely hope not. But I want to start off with, I don't have a topic for the presentation, but a theme, more or less. And I want to start with a headline in relation to a matter I determined not so long ago. I did what I think was good work as a criminal judge. And the headline in the newspaper the next day read, "Murder accused to be released after a year in prison." And of course, what followed was a social media frenzy with lots of very unpleasant remarks about the judge and the judge's family and etc. It's all my dog. They're supposed to kill after that, I suppose. But sometimes the lens through which we look at the criminal justice system is what causes us to take a very skewed approach. And I want to encourage us to look at things a little bit differently. And I'm going to put a bold statement out that in the absence of sanctions, undesirable behaviors will likely continue with impunity. That newspaper headline said something to me. The public and the social media comments, the public did not perceive there to be a sanction for the undesirable behavior. And when I look around my country now, I'm not surprised that certain behaviors, undesirable behaviors, seem to continue with impunity. I told a good friend of mine I was coming to Barbados to speak today. She has to be a friend to be that facetious because she said, "What you going to tell them? What not to do?" So I stand before you honest. Trinidad is in a difficult situation right now. Just last week, the number of murders ended up in the double digits. We're in a really bad place. I heard a little bit about your numbers just now with the number of indictable matters, the active pending caseload in the High Court and in the Magistrates' Courts, and you seem to have a high caseload yourself. It's a fact that within the region, comparatively speaking, in terms of the active pending caseload, Trinidad and Tobago might be the worst of the lot. So I'm not here to tell you to stand up as if I'm your big sister and say, well, look at us right next door, we're doing really good. What I can tell you is that backlog that I inherited when I was sworn in as a High Court judge at the end of 2017, I did not create it. It's a little bit unfair. I didn't ask for that much work. I didn't ask for cases that were 20 plus years old. But that's the job I signed up for. And therefore, I'm responsible for it. I heard it said a little while ago from a former Chief Justice that, or the presenters, that there's a national effort to develop strategy. But I want to encourage all of you. The only way national strategy will ever be successful if you start by looking at the man in the mirror. So that's the context within which I want to present this morning to you. So I've been in the criminal justice system in some way, form, or fashion, in Jamaica first and then in Trinidad and Tobago for about 22 years. But I've been a judge for just about 5 years, just over 5 years. And in the 5 years, the caseload that I inherited somewhat unfairly, I've seen so many reforms take place. So that I think I'm spectacularly fortunate. I don't suffer from a particular syndrome called the good old days. I think that hinders many of us when we try to implement new strategies, innovations, reforms, progressive thinking. And I want to encourage you to shed that the good old days syndrome from yourself and try to embrace what is needed to take Barbados out of the situation it's in now by looking next door. So instead of me presenting to you what you could be, may I present to you what you don't want to be? I say it in honesty. There's a saying in Trinidad, if your neighbor house burning down, wet your own. My hope today is to share with you some of the initiatives in Trinidad and Tobago which we've implemented and are implementing. And Barbados, if you see any utility in them, you might wish to adopt them quickly, adapt them suitably, so that you stem your own tide and reduce your own burden. One of the things that happened almost as soon as I became a criminal judge, is that the system, the antiquated registry-heavy system, changed immediately. The Chief Justice implemented the individual calendaring system, or the docket system. There were 10 judges at the time. He took all of the cases in the system, divided by jurisdictions, 3, San Fernando, Port of Spain, and Tobago, weighted the cases and apportioned them almost evenly according to your degree of experience. I got 1/10 of the caseload for San Fernando, Port of Spain, and Tobago. And that was mine, individualized to me. No longer was there a system of you are rostered to this court for 3 months, you are rostered to that court for 6 months or a year. And then you do what you feel you can, and as you leave, someone else will take it over. No, what was assigned to me is mine, and I am responsible for their determination. So with just a year under my belt at the time, my apportioned caseload was staggering. So I did the maths. I heard someone, an earlier speaker from the bar, speak about the simple maths. Well, the simple maths beat me then, because I figured out if I could do as much as 2 trials a month, took no vacation, so that's 24 a year, with the caseload they gave me in February 2019, it would take me about 6 years to finish them. That does not take into account any new cases, nor did it take into account the possibility that some cases in the assizes are so serious that it will certainly take much more than 2 weeks to complete. Someone said it earlier, you cannot try your way out of a backlog. But what the individual calendaring system did is it made each judge take ownership of the disposition of the assigned active pending cases. Did something even more important. The judge now has to take ownership, not only ownership, but stewardship of new matters from filing to disposition. So while I said it was unfair for me to have inherited those old 20-year-old cases, anything that's filed now, I have nobody to blame but myself for the management of them. There's the ability now to generate what we call comparative statistics. I will duck if any judge pelts me. But I know we don't like to talk about performance appraisal for judicial officers. I did duck. I know we don't like to talk about that because we have security of tenure and constitutional appointments and such, but it comes down to you, the man in the mirror. You are responsible for managing your caseload and your docket. So how do you measure your own performance if you cannot be measured objectively? It might be just self-reflection and honesty. So what the Chief Justice also did is he started to give us anonymized, so it wasn't meant to embarrass us, anonymized periodic statistics. So you get a table, you only know who you are, and the other judges are A, B, C, D, etc. And you can see for yourself how your performance measures up against them. The rest is on you. Remember, the man in the mirror. And it also gives you, if you're progressive enough, the ability to look at your statistics and see what's working for you and adapt to suit. That was February of 2019. February of 2020 came another change. We commenced what we called criminal masters and judge master partnerships. So we bifurcated the system of case management. So the masters do much of the case management for us, while the judges are able to focus on trials and other non-trial dispositions. It gave us the ability to use our sitting time more usefully. Masters, by the Criminal Division and District Criminal and Traffic Court Act, have the power of a judge in chambers. I'm going to, in the interest of time, I'm going to adapt some of what I'm saying, but I will share this afternoon and maybe over lunch as well. The component with the partnership is a little bit difficult for judges now, so we now have to learn how to collaborate with another judicial officer who has a degree of autonomy and not have that judicial officer interfere with our autonomy as well. So it's challenging. If you want to implement it, consult and do some exchange visits to see how it works with others. But what worked for me is I found that with my partner master, I could develop a database of all my cases so we can see it from a bird's eye view. and we're able to put certain types of matters into categories, what we call baskets. So you have the two witness basket. You have the victim might be deceased basket, victims out of the country basket, voir dire basket, different types of cases, because what you want to get to is an assessment of how much of your time ought you to apportion to individual cases. Then you look to your calendar to see when my calendar should I schedule this. And you'll see it coming together. Imagine a highway, if you will, not with roundabouts, but with exits, proper exits. So if you get into a lane where you, according to your basket or your categories, where you can come out earlier, then you get off. If, for example, you adopt judge alone trials, you might get into the fast lane and you overtake some of the jury trials, just by way of example. We implemented a fast track court as well. I heard it mentioned earlier, this might be a strategy that you can use. It is managed by the Registrar of the Supreme Court, and it covers those cases where persons have already been committed after the preliminary inquiries, but no indictment has yet been filed. Some of those persons want to plead guilty. So the registrar essentially manages that list with the assistance of someone from the Office of the DPP to fast-track the filing of the indictments. They get off the exit. They come off the highway. Yeah? Another exit off of the highway is the MSI, and you use these already. May I suggest that you use them a little more robustly? And when you use them, dare I say this to judicial officers, incentivize them. Don't compromise the integrity. You don't have to step outside of sentencing guidelines and precedents, but incentivize the process. There is something legitimately to be gained from guilty pleas. The criminal justice system ought to be interested in convicting the guilty and acquitting the innocent. Incentivize guilty pleas. That was a criminal defense attorney clapping. I take that as a singular source of congratulations. Now, I've built into my MSI process incentives where I don't feel I'm compromised. So I give you the starting point, but I go further. And I tell you, I don't know what the methodology is in Barbados, but in Trinidad we call it Aguilera. Tier 1 is relative to the offense. Tier 2 is the aggravating and mitigating personal to the offender. Then the 1/3 discount for the guilty plea, then time spent. So I tell them, because I may have seen on the papers, or I read from a bail application, or I saw an affidavit somewhere, that there is something good in the form of mitigation. So I will say in my MSI indication, this is the starting point. However, unless something changes, I see room for downward adjustment at Tier 2. I go further. I get from the prison department the time spent, and I go all the way down to Tier 4 to say, this period will automatically be subtracted. What I help the accused persons do when I do it like that is to do the simple maths for them. At the end of the day, they say, my worst case is the next 2 years. I know the public doesn't like that heading. Man convicted and only gets 1 more year. But that case gets off the highway, takes an exit, and we can move the criminal justice system along. We've also implemented plea bargaining, which is picking up steam now in Trinidad by Act number 12 of 2017, and it applies to both indictable and summary matters. I commend a robust regime for plea bargaining in Barbados. Again, if you're interested in a criminal justice system where sanctions will be applied for undesirable behaviors because you don't want it to be repeated, convict the guilty. Our plea bargaining provisions are very flexible, but I advise whatever legislation you pass, engage in robust training, especially for the prosecutors. I personally have had some problems with the drafting of agreements, and I've done a few decisions on it. I'll be happy to share it with you, Chief Justice, about them. We've also set up the Public Defenders Department in Trinidad and Tobago. I hear about a very small bar in relation to criminal matters. The Public Defenders Department has really been very useful. In addition to that, we have the practice direction on the appointment of public defenders, which is fairly recent, where the Chief Justice has indicated if the defense attorney is absent for 3 occasions, consecutive occasions, the court can appoint a public defender. where the absence of the attorney impacts on the progress of the case. You do not need the consent of the accused or his attorney for that. So if you find the absence of the attorney is slowing down the progress of the case, we appoint a public defender. That has worked. Not just because we get the public defender's department in, but the threat of removing someone from record causes them to ask for more reasonable adjournments and times when they are sure that they will appear. I've heard about the criminal procedure rules that you have in draft, and I'm going to tell you, put every ounce of energy and effort you have into that and get it going. Establish it and work the rules. The overriding objective of our rules is that criminal cases be dealt with justly. And it's the duty of the court and all parties and participants at every stage of the proceedings to further the overriding objective, not just the morning of trial. It says that dealing with cases justly requires both defense and the prosecution to be treated fairly, to ensure the protection of all rights of the accused. Consider the interests of accused, witnesses, victims, and jurors, and keeping them informed of the progress of the case. You can't tell me on the morning of trial you now suddenly wish to object to a confession statement. I'm going to have to send that jury away and then call them back weeks later. Deal with cases efficiently and expeditiously. And you must take into account, and this is where we have to balance and weigh resources, take into account the gravity of the offense and the relative complexity of cases. Not all indictable cases are equally weighted. With all due respect, there are some white-collar offenses that are more complex than murder cases. You look at the needs of other cases. You look at the consequences for the accused and others who may be affected, and this is what you do. Weigh it all up and allot to that case an appropriate share of the court's resources while taking into account the need to allot resources to other cases. Active case management is required by the criminal procedure rules, and this is what active case management means. Early identification of the real issues. Now I might have to duck from the defense attorneys because what we're required to do is to identify early the nature of the defense. Both sides must come prepared to lay their cards on the table, and we avoid trial by ambush. So we also have, in pursuant to the rules, a practice direction on defense disclosure. Now, at first, we expect that the prosecutor will disclose all that they have to. The practice direction requires that defense statement to be filed within 56 days of receiving all of their disclosure. The sanction for noncompliance is the possibility of an adverse inference being drawn by the fact finder. In monitoring the progress, active case management requires the monitoring of the progress of the case and compliance with directions. So we establish a case progression officer. There are no case progression officers who hold that title anywhere in the judiciary of the Republic of Trinidad and Tobago. But I have a judicial secretary, and I don't need her to make my personal appointments for me. What I need her to do is to help me manage my caseload. So we developed a simple Excel spreadsheet, and you put in the directions, and you call the lawyers, and you remind them. The truth is the attorneys are sometimes very, very busy, and they lose track of deadlines. I don't think they intend to disrespect the court. And I have found that gentle, courteous reminders from my case progression officer / judicial secretary has helped with compliance. And I get filings done in time. We're required to encourage the parties. Any prosecutors in the room? Encourage, they are the most uncooperative when it comes to this part, that's my experience. Encourage both sides, all parties, to cooperate in case progression. For some very strange reason, it is the prosecutors who tend to hold themselves rigid, and it's almost as if they don't want to come to the table with the defense attorneys. That's just in my culture. I'm not saying it exists here. My culture, right? But the point is, the criminal procedure rules, the focus is judge-led, issue-driven case scheduling with allocation of judicial time as a scarce resource in a case-specific manner. I found that it works. We have, and I encourage you to look at your Evidence Act as well, we have formal admissions by Section 37A of the Criminal Procedure Act, where if the evidence is non-contentious, there's no need for cross-examination. The parties can agree to the evidence formally, and it is read into evidence, whether it's a judge-alone trial or it's a jury trial. That has saved time. I did a murder case, I kid you not, where there was one eyewitness. The parties, that was a cooperative prosecutor, the parties formally agreed to every other witness except the purported eyewitness. That was the only witness they wanted to give evidence viva voce, the only witness the defense wanted to cross-examine. It was a jury trial and ended up being an acquittal. So with formal, that was a one-day trial. One-day trial, yeah, a murder. We have judge-alone trials in Trinidad and Tobago, and I believe you now have, Chief Justice, the new bench book, the new criminal bench book for Barbados, Guyana, and Belize. I think it was launched just last month. There's a chapter, a lovely chapter in that book about the judge-alone trials. And they do exist in some form in the following Caribbean states: Jamaica, Belize, Cayman Islands, Turks and Caicos Islands, Antigua and Barbuda, Trinidad and Tobago, but not Barbados yet. St. Lucia is in the drafting phase at this time. It's up to Barbados to make its choice. It's the same burden of proof, same standard of proof. There's no need to sum up to a jury. There's no need to attempt to find the precise formula to give sometimes complex legal principles, often overlapping with each other, to lay persons in a way that survives appellate scrutiny, by the way, and in the hope that the lay persons remember each direction, keep them in view as they deliberate, and apply those directions properly, all in this search of the elusive justice. The regional approaches are quite different. In Jamaica, it's only available for certain indictable matters. In Belize, for example, judge-alone trials are mandatory for some types of offenses, discretionary for others. In Trinidad and Tobago, any indictable matter can be a judge-alone trial, even if the death penalty attaches automatically, but only at the election of the accused. So it's up to you to look and find what you think works for you. There's a distinct advantage in that we can't ask jurors why they're acquitted or convicted. We can't. But in a judge-alone trial, depending on how you draft your legislation, there's a duty for the fact finder to give reasons. Doesn't that augur better for public trust and confidence in the criminal justice system? I saw your criticisms and your concerns about judge-alone trials. But where the judge has to give reasons, whether for an acquittal or a conviction, doesn't that engender more confidence in the judicial officer? Doesn't that augur well for the fact that you have your own appellate court, your own apex court right here in the region? I'd like to see it develop in my own country. A practical example with judge-alone trials is what you do with voir dire. In the last few trials I have done where we did the voir dire, and for those who don't know how it works, I know then not everybody in here is a practitioner, where you have issues of admissibility, sometimes confession statements or so in a jury trial, in the absence of the jury, the court is required to subject that evidence to some assessment and scrutiny. Only if it passes, then and only then is the jury permitted to hear that evidence. It becomes admissible then, and it's up to them to attach weight. When we're doing a voir dire, which requires a number of witnesses sometimes, you have to send the jury away. You empanel them, arraign and panel, send the jury away, do the trial, the voir dire, which is called a trial within a trial, and then you bring the jury back. And some of that evidence, and this is the point, some of that evidence in the voir dire has to be repeated for the benefit of the jury. In a judge-alone trial, there is no need for that type of rigid demarcation or ring fencing of these issues of admissibility. So what I've done is I've done the voir dire, made a decision, and incorporate the evidence into the main trial. So the prosecutor simply asks for the evidence to be incorporated, marshal whatever additional evidence in chief there is to be, and then there's cross-examination. It saves time. So it's a practical reason that you might want to look at judge-alone trials. We also use a lot of virtual trials, and all of my trials are hybridized. So I'll give you an example. Last year, I got COVID at the end of September. with a jury trial to start on the first working day in October. A jury pool summoned in Port of Spain, and our Minister of Health decided he would quarantine me under penalty of fine, etc., and a lot of public embarrassment. So I had to stay at home. I was not ill. I was asymptomatic. As far as I was concerned, I could work. There's a jury pool there, and this old case I need to get done. Because there was no objection in that case, and I'm grateful to the parties for that, I sat in my house in South Trinidad and pulled a jury at the Hall of Justice in Port of Spain. And my trial started. And as soon as the quarantine was lifted, I was able to go back in person. So there are advantages to virtual trials that maybe are outside of the box you need to look at. Witnesses who are abroad, especially if you have cases that are 10, 12, 15, 20 years old. Witnesses who aren't able to get to you in Trinidad. We have a lot of flooding problems sometimes. We have a traffic problem that detains people and keeps the court back. Every little delay adds up to the system that we have right now. You could sit where you are and give evidence. We've created VAC centers, virtual access customer centers, for those persons who don't have the technology. We set them up at different locations, some even in the courthouses. A room with a device and someone there to assist you. If you can, you connect to the court and you give your evidence right there. So those are some of the advantages. But the real thing that has helped us, pulling all of those things together, is what we call trial date certainty. If you do all of this, you manage it, you narrow your issues with formal admissions to only what needs to be tried. All the MSIs, plea bargains, they are out. This has to be tried. And you fix a trial date. You've narrowed it down, you know exactly how many witnesses. That's the date to start. Come the morning of the trial, invariably, a million different reasons why that trial can't start. It's on the judges, the judicial officers, the man in the mirror. If you say trial date certainty must be your philosophy. I have made it very clear, barring death and grievous bodily harm, it's starting. I don't even accord to myself the excuse of illness. If you permit me a little indulgence, I am now in remission from cancer, and I did not allow anything to interfere with trial date certainty, even while I was doing chemo and had surgery. I don't mean that in a false way. I'm simply saying schedule appropriately. So I heard someone say, let courts sit every day, Monday to Friday. While I was doing chemo, I didn't sit Thursday and Friday. I need to catch myself. I had to be smart about it. But Monday, Tuesday, and Wednesday, trial date certainty. Let's get on with it, because I have chemo Thursday. Can't keep it back. So that's what I mean. Make it make sense for you, but make it work for the system. Make it work. It may mean you have to do some adventurous things. So I run parallel trials sometimes. I will start a jury trial and maybe run a judge-alone virtual trial in a parallel manner. Because I was able to do that in the month of April, I was able to complete 2 jury trials, 2 judge-alone trials, and 2 MSIs. And we took 10 days for Easter. And that's because of robust case management, tight scheduling, and trial date certainty. So I think I'm past time. I had, okay. The children court. All right, I heard. When the Honorable Prime Minister asked you to repeat what you said, and she heard you say it, then you know you have to repeat it. I will. It's shifting gears a little bit. So I've been focused on the adult system, the system I operate in, but this is shifting gears just a little bit. And PM, I'll stick essentially to what I said. I started off by saying that, you know, when we think about suppressing and contending with crime, we often think of it in terms that are daunting. We think of it as a Herculean task, so I gave the analogy of Hercules. The second labor of Hercules was to kill the Hydra, you know. that monstrous 9-headed serpent with its poisonous venom. And quite often, the way many of us in this room approach contending with crime and the criminal justice system is it resembles the early Herculean efforts with the Hydra. I don't know if you all know the story, but when Hercules went to kill the Hydra at first, what he tried to do was to bludgeon it to death. And as he killed each head, was mortified to find that resurrected in its place 2 or 3 more heads. That might be how we've been going about dealing with criminal justice. So I'm going to start this part of it by telling you a story. It's a true story. It's about a young man who I will call AB. At the time, he was 14 years old in Form 2, second year of high school, in a school in Trinidad and Tobago. He was living with his mother and father and an older brother who was then in Form 5, about to write CXC. And he was suspended from school under the school's zero-tolerance policy on violence. These were the circumstances. And it is only after the suspension had been ordered, pen dry, the ink is dry, that the full circumstances were discovered. See, the night before AB's suspension, his father badly, brutally beat his mother. He struck on her head with a pot, a heavy iron pot, to use for stews and curries. The Jamaicans call it a Dutch pot. Struck on her head, rendering her unconscious. The older brother, who was then in Form 5, intervened because the father, though the mother was unconscious, he didn't stop beating her. Now on the ground, out cold, the bigger brother tried to intervene because he didn't want him to outright kill her. Daddy beat the brother badly, breaking his right arm, which was his writing arm, and he's about to write CXC. And he ran from the house because the father was going to kill him. Police were called. 14-year-old AB is left at home now, alone, because mommy was carted away by the ambulance, and daddy was arrested by the police. He's in the police station. In the morning, 14-year-old AB gets up. Well, I don't think he slept. Dressed himself and went to school because he just simply had nowhere else to go. His head was on the desk when Miss came in. Miss said, "I don't want nobody sleeping in my class, boy." See, Miss wanted to do right by her students, including AB. She wanted to deliver the curriculum. Rightly so, she needed all of them to sit up and pay attention. So she went up to AB, who didn't raise his head, and she beat the desk. "Boy, I say I don't want no sleeping in my class." And that's when AB, although only 14, tall and big, stood up, all 6 feet of him, stood up in front of Miss, diminutive, about 5 feet, and said, "Miss, don't let me damage you today, eh?" Raised his hand, and he was suspended. The suspension letter required him to go home immediately because it was an act perceived to be violent to the teacher, and they had a zero-tolerance policy. But the letter also stated that he could only return to school accompanied by a parent. Mommy is unconscious in the hospital, and daddy is locked up at the police station. Now, I said it then and I'm saying it again. I am not saying that we ought to tolerate violence in schools. I'm not saying Miss was wrong, principal was wrong. I'm saying just go with the story. You see, it's been said that repeated exposure to multiple forms of violence place children at greater risk of repeating these behaviors and modeling patterns that they perceive as normal and appropriate. Remember, we're thinking about AB. The judiciary in Trinidad and Tobago took that into consideration and changed gears in the approach with dealing with children who find themselves in conflict with law. First thing that was challenged was the nomenclature. We changed the name. The idea of juvenile courts, juvenile delinquency, children in need of discipline, etc. They changed it completely. The old Summary Courts Act that captured those children, you know, there's a provision in the Summary Courts legislation for parents to bring the children to court when they start to really get out of control. They used to be called beyond control cases in Trinidad. They're now called CHINS, Children in Need of Supervision. So it started with the labeling. And I'm not a social scientist, but I understand a little bit about the self-labeling prophecy. So it starts there. But the focus in general of when we created the Children Court is on rehabilitation, restoration, and reintegration. 3 R's that I hope you remember. Now, of course, I'm not saying anything about the presumption of innocence where there are charges. Of course, that's a given. But regardless of the ultimate outcome of a criminal charge, whether by MSI, by a guilty plea, trial with a conviction, or even trial with an acquittal, it doesn't matter how it ends. The fact is that once they enter the system at the Children Court, an intervention takes place. And that intervention does not touch the child alone. A psychosocial assessment is conducted to identify all the factors at play or which might account for why the child is actually before the court. So while the child has been arrested in the criminal justice system and charged, even before that charge is determined, the Children Court seeks to first arrest that child's circumstances. That's the priority. And the court, with its team of social workers, child specialists, including mental health professionals, develop a plan and recommendation for the judge or judicial officer. There's a suite of interventions that are applied, bearing in mind the psychosocial development of adolescents. They are not little adults. It's a completely whole different human being. That suite of interventions might include counseling for the child, counseling for the parents, joint counseling, counseling for a guardian because you may have to take the child out of their home situation. It might include grief counseling, because it might be that that child is acting out because daddy was killed. It might include parent workshops, because whether we think there's an age that comes with reason to begin parenting, and we like to say it's because we have young parents, no, I'm sorry. Even people who have children well in their 30s, they don't know how to parent. And they have to be taught, so we send them to parenting workshops. So it's a holistic psychosocial assessment with a suite of interventions. And one of the interventions is education. I heard it said earlier today. Literacy is tied to recidivism. So for certain types of matters, the less serious ones, one intervention, and this is in a case where they plead guilty for a lesser offense, we have what is called peer resolution. This might be interested for some organizations here. We have court-annexed peer resolution, which is a process where youth volunteers ages 13 to 17 assist the court. They hear contributions from 3 peer advocates, a respondent advocate, victim advocate, and a community advocate. They consider, this is the 13 to 17-year-olds, they consider all of the issues. They hold discussions to discuss the child's interests, goals, and challenges, and then they make a recommendation to the court. Ultimately, it's the judicial officer who determines the case, but it's the peer assessors who make the recommendation. It might be a sanction that is a letter of apology, might be community service, might be counseling. Remember, it's guilty pleas for the less serious offenses. Peer resolution builds accountability. It offers second chances. We take a zero-tolerance approach to something like what AB did. But that's a less serious offense in the long run and in the regular scheme of things, in terms of where he could end up. Because the next time somebody intervenes, he may actually hit them. It serves as an early intervention solution. Nobody inquired really before they punished AB why he behaved that way. Early intervention solutions would have afforded that entire family some assistance. I never asked, but I doubt that AB's brother wrote his exams. Remember, his writing arm was broken. I never inquired. You see, the children in the peer resolution framework have a say in how to solve problems with children, and it builds community connections. So the child offender and the peer assessors build each other up. Let me, who look like you, who sound like you, who understands you, let me try to help you. Now, about the more serious offenses, custodial terms are, of course, a last resort. But for the serious offenses, whether they involve a guilty plea or a trial and conviction, and whether it involves a custodial or a non-custodial sentence, we have this very important feature in the children court. You know, typically we say that the court is functus after sentencing. That's the end of your business. You're sentenced, custody or non-custodial, and you're done. What happens in the children court is that judicial oversight concerning rehabilitation, reintegration, and reducing recidivism continues post-sentencing. So even if it's non-custodial, the judicial officer brings the child and the parents back sometimes and continues that oversight. It's something we don't have with the adults, and I wish we did have it for some of our cases, but that's bringing more work on me, and I'm not sure I have the time for it, but it might actually reduce recidivism if we really, really think about it. Post-sentence monitoring. Crime begins somewhere, and I'll wrap up here. It might be a good place to end. The breadth of what I presented, I know is a little wide. But I said that I think of the beginning of crime as coming down to a human being. I started off by talking about the man in the mirror, by speaking about it from the perspective of the judicial officers. But crime begins with a man in the mirror too, one individual, like AB. In Trinidad and Tobago, some 18,000 children write our secondary entrance exam every year. That's the figure I use. 18,000 every year. It's been standard for the last few years. 18,000 children would have started kindergarten together, started primary school together, written that entrance exam together, started Form 1 together. And somewhere in that 18,000, they become those persons who have us in the situation that we're in. Somebody committed those murders in Trinidad last week. They were, each one of 18,000 at some point in time. I mean it when I say it. I take it to heart. The judiciary has signed an MOU with a tertiary institute to establish a program with the children court called the ARC program. A, accelerate their focus on thinking. R, restore them to society. And C, connect them with the right community and network for a purpose-driven life. We intend to combine academic development, psychological support, career coaching, and I don't mean just everybody must be doctor, lawyer, dentist, etc., but all of the other professions, the plumber that none of us, doctor, lawyer, and dentist, could do without. I don't know if it's very hard to get a plumber in Barbados, but it's incredibly hard. And somehow the pipe will only burst on a Sunday. Could never understand it. But we want to create a supportive environment that ultimately aims at promoting positive behavior and reducing the risk of recidivism. So I want to start off and end off right there. Consider the ABs, just like that child then. The ABs who are at the heart of why we're all gathered here today in the criminal justice system. I thank you for your attention. I think so.
Thank you very much, Judge. I think that we begin to understand why I felt that it was important for us to learn and share with each other. And I have no doubt that this afternoon you all will also share with the judge what you face and what we're doing. I have to leave at some point, but I want to leave you all with a few things. And this is perhaps one of the most important meetings, part 1 and part 2, that this government will deal with in the last 5 years. May is 5 years. COVID has robbed us effectively of 3 years. But I don't have the luxury of complaining. It is what it is. I ask you, and I've asked the Honorable Attorney General this afternoon when you return from lunch, the time in the name and in the language of a dear friend of Andrew Pilgrim and mine who is now gone, the lot of long talk has to stop. I need clear recommendations from the people who work in the criminal justice system in Barbados, and that is you all. You constitute the leadership. The AG will tell you, as will the Minister of Home Affairs, I have yet to decline any reasonable requests from the police or the judiciary in the 5 years that I have been Minister of Finance. My position remains the same. And if you doubt and you feel that this is equally a lot of long talk, I invite you to go to page 26 of the Covenant of Hope, where my government set out, even before becoming a government, the priority of claims on public expenditure when we were inheriting a government that was the third most indebted government in the world on debt to GDP per capita. Those priorities have not changed. The first is to keep Barbados safe, and that is why all of the expenditure in terms of the modernizing of a police service that is the third oldest in the Commonwealth. Sounds good to talk about historically, but it is a madness to deal with that as a reality in the third decade of the 21st century. Every rule and every system in the police service has to be deconstructed and reconstructed and must be completed before the end of September. And why? Because every department in the service has a leader. And therefore, if each division does what they're supposed to do, you can literally deconstruct and reconstruct. 2, you all need to discuss whether, instead of calling it the National Prosecution Service, because we don't need to create new institutions, we have a department of prosecutors under the leadership of the DPP. My father reminded me that in the early days when men like Richard Cook and Johnny Saltbag and them used to prosecute, it was because there was no law faculty. I can assure you that Johnny Saltbags and Richard Cook were better prosecutors and lawyers than a lot of people who qualified at the bar in this country. The opportunity, therefore, was not there. In a country that has over 1,000 lawyers, we should let police be police and let lawyers prosecute. Thirdly, you cannot have every little child using technology and the court behaving like if it was a Dickensian moment in the 19th century with the best of times and the worst of times and no technology and all analog. I can pick up my phone and dictate, and all I do is edit. I don't have to, if I had problems with my fingers typing, I don't have to do much typing with the dictation that is available in a normal phone. Let us use the technology. We are going to come to rule the day with AI for different reasons if it is unregulated. But let us use the processing power that is there and bring this country into the 21st century. Fourthly, because we are small, there is too much informality. It has to stop. If we don't literally live within the context of what is expected of us, and I give you the assurance that the next few years has to be one about reforming the institutions, providing the training, and holding people accountable for leadership. If we do those 3 things, then believe you me, we are going to manage the transition of a criminal justice system that is lagging, that is fighting for breath, that looks just like I was practicing in it 20 years, 30 years ago. We will bring it into the 21st century. Now, I asked the judge to also speak not just on the first set, but also on the children, because that is why we have established also within the Office of the Attorney General a Minister for Crime Prevention. There is no doubt in my mind, and these are the things that frustrate me as I lead this country. David, when you were Attorney General and I was Minister of Education, in 1995, I believe it was, or 96, go back, Frandell Stewart was actually shadow education. I amended and brought to Parliament amendments to the Education Act that made parents liable for the vandalism of their children in schools. In addition, we created the Edna Nichols School. Anybody knows what the Edna Nichols School was created to do? Prior to that, children who were suspended went on the block, stayed home and sleep, do what they want. With the Edna Nichols School for almost 30 years, and it was always phase 1, and phase 2 couldn't happen because the Minister of Finance wouldn't give me the money for it. Phase 2 couldn't happen earlier because I had to find money in the middle of COVID to save lives and livelihoods. And I sent the message in January of this year to the 2 ministers at that table, Abrams and Humphrey, that there must be the phase 2 to the Edna Nichols Center. And what is it? Edna Nichols Center will take the child who has been suspended for 3 weeks in the first instance, and if that child has not been able to respond, you have the capacity to extend them. I can't remember if it's another 3 weeks, but you can check the law. But after that is done, what we need now, phase 2 was always intended to deal with the fact that there are genuinely some parents who can't manage. And before a child gets into a criminal situation, there needs to be some kind of residential facility that can help nurture this child and to bring this child back in to an acceptable way of integrating into the society. And I ask the question, therefore, that the legislation that is needed, the child can get there or ought to be able to get there by way of the consent of the parents, or if necessary, where the parents themselves are the problem, through a consultative and consensual approach of the Chief Education Officer and the Director of Child Care, going to a judge in chambers and asking the judge in chambers to allow this child to become a ward of this particular, ward is a 19th century word that we probably need to change to be able to take responsibility for this child's parenting for the period of time. And to give children, that is why the government in an IMF program is taking up money that will cost us over $20 million to deal with the Barbados Youth Advance Corps. That says, and this is the other thing that we keep forgetting, when you don't have scale, you cannot transform. If you do it here and do it a little bit there, what it says is a nice academic discussion. But if you want to transform the criminal justice system, then you need scale. If you want to transform the education system, you need scale. So that what we're saying is that in the same way that I have found it possible to find the money for the Youth Advance Corps, including paying them a stipend to come, including moving from a youth service of 250 to a Youth Advance Corps of 2,000 people over a 2-year period, including building out residential facilities as we speak this summer, to house at least 250, 300 of them, because if you take them in a residential for 10, 12 weeks, you start the breaking of bad habits and the cultivation of good habits. So that a fellow who come in and play that he ain't making up his bed for the first 2, 3 weeks, believe you me, by week 4 he making it up. And if you look and talk to the people, it's ironic that we're talking now, because the Prince's Trust from King Charles III has actually done significant work in this country. And if you go and talk with them, ironically, the same Lionel Richel and Prince Charles as he then was, when they brought the kids together, and I talked with the kids 2, 3 years ago, what are they telling you? That they longed for that sense of belonging. They longed for that sense of affection and that sense of attention. And I'm saying to us that this is just the beginning. Now, this is a country where people used to belong to cricket clubs. And men, regardless of how poor or how rich they are, would gather, and boys who didn't have a father to look at or look for would help then, in those circumstances, help guide and mentor those young. Same with the young girls. that is what is also missing from our communities. So when I say that I can put money in cricket, I don't put in money in no cricket for no secondary school competition. I will put money in the Barbados Cricket League because I want intergenerational support and communication, and that is what we can get there. So I've taken this mic to give you all the assurance that as Minister of Finance and as Chair of the Cabinet, this constitutes the priority on public expenditure in this country. What comes next is public health and affordable access to health care. What comes next is education and empowerment. What comes next, and it is all set out there, but equally on that page is a recognition that a government's powers are not only tax and spend, that a government legislates, that a government regulates, that a government empowers, that a government facilitates. And what we need to do is to accept that Barbados has a crisis in leadership in too many institutions and at too many levels in this country. Now, a crisis in leadership is not incapable of being overcome, but we have to set about deconstructing and reconstructing what is our role, what is our function. And after we understand our functions, then structure comes. And after we get structure, then we come to people in the institution. And we need to make sure that the people who are people in the institutions have access to the training that is necessary. And then once we get that, it is monitoring and habit. Breaking bad habits, creating new habits. 6 months is the outer limit, 12 weeks to 6 months to break habits. And thereafter, monitor the habits every 3 months. Monitor them, monitor them, monitor them. Are we going to be 100%? No, because somebody can fall down at some point, and somebody can do something wrong, but that is the system. As Attorney General, I knew that I could not, or as Minister of Education, I can't tell you a teacher won't do something. I can't tell a policeman won't do something. But it is our duty to help and find out why, and see how the system can be improved, and if not, hold people accountable. And every infraction, because that's the next thing. If people feel that every breach leads to a dismissal, then nobody raises their head above the parapet. So that people equally who are guarding the guards and need to know that there has to be an analysis that gives people the opportunity and that we punish recidivism. We punish heavily if it is murder or sexual assault or whatever, but if it is a technical breach, if it is something that they shouldn't have done and that we feel that they should look at again, then talk through people. Second time, you get it in writing. Third time, you know a recidivist. Be prepared to take responsibility for your actions. If it is a murder where you don't get the 3 strikes, you go straight. If it is a rape, same thing. If it is dishonesty at a high level, same thing. So I ask you all, therefore, and the AG will chair, I believe, this afternoon session. Sarah is here to also assist, as do all of you. Do not leave in here without a clear set of recommendations for me as Minister of Finance and me and the Cabinet as the body who is responsible for settling policy. With respect to the parliamentary agenda, we need to have the legislation passed before the end of July, before we go to summer. Why? For every child, for every adult who becomes a victim of crime, we need to apply our hearts not just to wisdom, but to speed. And the reality is that nothing is above us. The last point I want to make is, when Arthur used to say all the time that you can't cross a chasm in small steps, he was absolutely correct. Barbados' criminal justice system does not need amendment or modification. It needs radical overhaul. And therefore, you start first and foremost by identifying what are the values and principles that must be defended. And I ask these questions in every area of government, as the others would tell you. What is the public purpose we are serving with the initiatives that we want? What is the public mischief that we must avoid? Does technology allow us to do this more efficiently, as clearly is the case with voice-to-text technology and Scopus or whatever you all call these fancy names nowadays? And fourthly, when we make these changes, who are the winners? Who are the losers? Who do we empower and who do we disenfranchise by the new rules that we are putting in place? Do we really need to have magistrates dealing with preliminary inquiries in the same way when we have a high court, a court of appeal, and a Caribbean court of justice? Do we really need to have a situation where, I mean, literally take it from beginning to end and determine what is there? When we deal with children, should we not have a holistic jurisdiction that is neither single jurisdiction to deal with children, that is more nurturing and accountable rather than adversarial, which is what I heard from the judge in terms of what they're trying to do there in Trinidad. So there's much work to be done. You are the leaders of the criminal justice system, and in a very real sense, regardless of what legislation we pass or what funds we put there, it is only going to make a difference when each of you in your institutions exercises the leadership and understands why we are here, what we are supposed to do, and everybody plays their part in the cog that will bring the radical overhaul to the system. So thank you. I'm going to look forward to the recommendations that come from this consultation, and let us get on with the business of keeping our country safe. Thank you.
I'd like to thank the Prime Minister for her address just now, and I'd also like to thank definitely Madam Justice Hines for her very interesting presentation. If you can give another round of applause for that. Thank you. And I'm sure that Madam Justice Hines will be available for when we get into the session, the next steps forward, any questions that might be needed to be answered by her. At this point in time, we will now break for lunch, which is just outside, and I will invite everyone to participate, but we will cut it to 45 minutes as opposed to an hour so that we can make up some time. So it is now 5 minutes to 1, so at 20 to 2, we are going to resume. Okay? So thank you very much and enjoy your lunch. So I was
And I'm going to have the floor open for question and answers to Judge Hines, Ransomere Hines, given her excellent presentation, but shortage of time to ask any questions before the lunch and adjournment was taken. So I invite members of the audience to pose any questions to Judge Ransomere Hines. She's up here with us and eager and ready to proceed. It was a very full, provocative presentation, and there must be a lot of issues arising there in which questions can legitimately be raised. So I leave the floor open. Yes, Billy, I can see you come.
I was just going to ask, Judge, what your preference or what your experience suggests is the better choice between the MSIs and the plea bargains?
You're not hearing me.
I didn't anticipate that question, and I don't think I've ever addressed my mind it. A preference between MSIs and plea bargains. I think what I like about the plea bargain process is that it allows the prosecutors to consider whether or not they really have a good case, and that they can consider joint gains to the criminal justice system. So I like that overall. That's probably a broader, admirable goal, I suppose. But personally, I have more control over the MSI process. The plea bargains can take a lot of time because they quibble. So for example, I had a plea discussions taking place. The most they could agree to was a recommended sentence range as the starting point, and the range was 2 years apart. And I can't for the life of me understand why a prosecutor and a defense attorney could not narrow that 2 years down. I came down in the middle. I just came down in the middle. They were both right. The range, the starting point could fit squarely inside there. But you know your brief. Defense knows their brief. They've disclosed their hand already. Come down in the middle. But I have more control in the MSI process. Yeah, I think so. And it gives me the opportunity to try to appropriately incentivize guilty pleas. Plea bargains, I think sometimes we still need more buy-in from the prosecuting side of it, if I could be very honest. But I think in time that will change. Yeah, I hope that answers the question. Yeah.
Is there anyone from the DPP's office who may want to make a comment on this?
Thank you, Chief.
Yeah.
Very provoking.
Yeah. I saw Alliston earlier. Anyone from the DPP's office? Because I think we would need a response from that side to balance it somewhat. Not at this time. Well, he is gone temporarily? Oh, okay. Yeah, I invite Sarah to make a comment.
Just an observation, with the code for prosecutors that the DPP's office has, doesn't that in itself allow you to a degree to do plea bargaining without legislation?
Yep.
Certainly when I operated as a prosecutor, I would use the code to accept lesser charges. I would have discussions with defense, and that's how, so we would do plea bargain, but not in the typical legislative format. Just throwing that out there to the DPP's office, that already I would say it does exist and it is possible to do.
It existed even in Trinidad before the legislation in 2017. So, for example, defense attorneys would write to the DPP or talk to the prosecutor there in the courtroom to speak with the DPP. Will you accept a plea to a lesser count? Will you oppose a non-custodial sentence? So it's always been happening, so there's nothing to stop you now. What I'd like is for prosecutors and police officers who lay the charges to be realistic. Consider the witnesses that you have. On paper, it may look good. It may look as if you can establish the elements of the charge, but do not for a minute forget the standard of proof. We talk about burden of proof, but we don't think enough about standard of proof. If you cannot prove your case beyond reasonable doubt, you're going to have an acquittal. Isn't a conviction for even a lesser count something more just than an acquittal because a witness isn't accustomed to the courtroom or doesn't stand up well to the pressure of cross-examination or is re-traumatized by the process. So consider the whole and what does justice really mean to your side, knowing the people you're dealing with.
I think that ties back here. I think that ties back in with the need to be expeditious, right? We incentivizing and taking those kinds of steps are the only thing that are going to save us, because we can't get through, you can't fight through this backlog. And I have to say that the DPP's office, they are starting to look in that direction more, I think. But we have to constantly remind ourselves that we can't try our way out. There's just no way. So we got to find some of these smaller cases, as you would say.
Low-hanging fruit, go for it. 2 witness cases, or that are really old, and be slightly bolder. And ask the prosecutor, are you willing? I mean, if you don't get good feedback, you know what to do. You may just step back into your crease.
Yeah.
And even the prosecutors, just test it. The culture will begin to change. It was slow to change in Trinidad, and it is still changing, but it is growing. I mean, we don't ever want to start to look like North America, where we just rubber stamp plea bargains. We do not want that. I have a real difficulty with that system. But we do need to go for the low-hanging fruit and plead out some cases.
It came up before, but like under our forgeries, if I forge a check for $1, that has to go before judge and jury.
Yeah.
So once that's before judge and jury, then sometimes you have to ask the prosecutor and talk a little bit and see if you can. And as I say, especially as currently constituted, this is not to say anything about Ms. Donna Barber. I know that myself and Alison are colleagues who've been fighting in the trenches for a long time. I can go to him and say, well, look, this one, we know it ain't really worth that much.
Yeah.
I look into throwing the sponge and so on.
Yeah, it's like Trinidad, sacrilege, the offense of sacrilege must go before the High Court. Even if it was to just steal a gas tank from the back of the temple, and what you did is you broke something along the way. You destroyed some property. It's now not malicious destruction of property.
Sacrilege.
Which could have been dealt with in the summary courts. It's sacrilege, indictable exclusively, and must go to the High Court. It's, so we have antiquated laws, and we need to change some of that. Yeah.
Flexible.
Andrew, don't leave yet. I wanted to ask you, what are some of the weaknesses of the current MSI that we have system?
I mean, I think generally speaking, the MSI thing is a good thing. And, sometimes the two parties, as the judge pointed out, may seem far apart. But I think the challenge sometimes we meet is that it feels effectively like if we've pleaded guilty and done a mitigation, and sometimes, we wait on the pre-sentence report. God help the poor probation department, they're under pressure. So you wait 8 weeks for that report, when really what we want to do is and I hope I'm not being unfair to Justice Birch. Justice Birch, when he was in the magistrate's court, he would say, come and talk to me, guys. Where we are. Y'all out here, and y'all out there, let me get this thing going.
Yeah.
And so you don't want it to become so informal that it's ridiculous. But you want it to be as proactive as possible. And if probation department, any officer at any given time got 15 reports due next week, Monday, it's just a pressure on them, and we need the report. But if you effectively have to wait 8 weeks to be able to do the MSI, and it's sometimes 3 months and you ain't finished the MSI, and it can be real problematic.
Yeah. We have the same situation with the reports, if the reports are requested for the actual sentencing process. I try to schedule it in a way where we don't feel the effect of the time. So for the MSI process to be triggered, you have to file the request for the indication to be given. So I almost begin from then.
Instantly.
To time it, assuming, so I mean it's more hope than anything else. I don't get to consider the report in giving the indication because that's a tier 2 thing, factors personal to the offender. But I time it from then. So as long as they file it, I can trigger from chambers the request for the report to be done. I deliver the MSI in a sort of timing so that the report comes in fairly quickly. So I set it up almost for, let's be realistic, almost everything in the courtroom is theatrical. And if you understand the script, you can work it to your advantage. And to help the parties appearing before you believe in the system as well and that it's working for them. No matter how broken it is, find a way to make it resemble as close to a whole healthy thing as you can. And that's what I try.
'cause the temptation sometimes might be to cheat it and say, if this person receives a favorable report, I would be in this position. But again, that may be becoming so informal that
No, but you could build it into an indication and say that if there is a favorable report at Tier 2, I can see a downward adjustment of up to 2 years or something to that effect. You protect yourself, even doing that.
We have a lot of non-lawyers here.
Oh, I'm sorry.
You may need to explain MSI simply and the different stages of sentencing so they're followed.
Yeah. Thank you, Chief. And for the non-lawyers, an MSI is a maximum sentence indication. It's essentially a man who, a litigant who is not sure that he wants to plead guilty, but he might want to plead guilty, but he just wants to test the judge out to see, what's the worst that judge will really give me? It really is, what's the worst that could happen to me if I plead guilty? No. That literally is what it is. What's the maximum sentence indication? And it really is an indication of what's the starting sentence. Our sentencing rules across the entire region look the same. It's a 4-tiered structure. Starting point relates to the offense only, that bad thing you did. Then you go to the second step, which is, who are you, the offender? Is there something that mitigates what you did or aggravates what you did? And it could change the starting point up or down. For a guilty plea, which is the third step, for a guilty plea, ordinarily, it's a 1/3 discount, ordinarily. And then at the last level, you take away, it's a mathematical subtraction, all of the time spent incarcerated pre-sentence. So it's 4 steps to the sentencing. And right, the earlier the guilty plea, the better. So what interferes with that guilty plea discount? Depends on whether you strategically did it at the last possible opportunity. You mightn't get that 1/3 there. So we have to justify it. The judges have to be careful about drafting that and justify it properly. But there's a way to get around it. There's also a way to get something more than 1/3. And I have found in some cases, even though I give an MSI for a marginal custodial sentence, when I get a really good plea in mitigation at Tier 2, I abandon the methodology and say no useful purpose is served in a custodial sentence. And I may place the person on a bond or under the supervision of a probation officer, something to that effect. So again, what's the use in keeping somebody another year in custody, costing the state thousands of dollars each month when they've already been incarcerated? Our system is fairly bad. Already been incarcerated for upwards of 10 years. You know, the maths it doesn't add up at that point for the taxpayers. Yeah?
Thank you very much. Alston, Deputy DPP, I invite you to go to the podium, or the microphone. We're talking about plea bargaining, MSIs, your department's position on them. Okay. Please.
I was told to introduce myself when I come to the mic. Yeah. So everybody might not know Alston.
I think you might be silent.
You're not hearing? Oh, you have to approach it closely. I'm Alston Seeley, Acting Director, Public Prosecutions. Now, my challenge with MSI is really, some things are merely procedural. First of all, when persons are in custody, MSI might work better. When persons are out in bail, and for serious offenses, and they still have to go back, there's a possibility of a custodial sentence being served, they're kind of reluctant. I must admit, I have 2 MSIs before the court that have been there for 2 years. This is just MSI. So sometimes the system is stressed out and stretched out because at the end of the day, you're going back to prison. So persons are not really, that's not so attractive. So you get the MSI system going like that, and to the average person that doesn't understand the MSI system, you don't have to accept it. So after spending 2 years in this system that I am in, with 2 matters, 2 very serious matters also, at the end of the day, what the judge gives as the tariff, they can say, look, I don't want it, and I go to trial. Now, that same system could work against me because my complainants, important witnesses, can die during that period. And my case now is hamstrung because of these variables that occur during the system. So, you know, if it is being used effectively for the purpose that it should be used, I'm glad for it, I'm happy for it. But there would have to be some constraints, as far as I'm concerned, with time. How long do we take to do an MSI? And, well, this part might be a little difficult, but the commitment to it, should you be able to go into MSI and say, I just don't want it? I mean, if the time is, if we do it in a short time, then you can afford to say you don't want it. But clearly, if you're going to take 2 years to do it, and then at the end of the time you recognize that whilst going through the process, you're saying, well, look, witnesses are dying. And then I can say at the end of it, I want a trial. And you put me to trial knowing full well that my case is now disemboweled. That is a severe challenge I have with the MSI as it is.
Learned DPP, the lens is everything, the perspective that you look at it from. So when I hear someone tentatively on bail, they're on bail.
Yes.
So they don't have, they're not in custody, their backs aren't against the wall. They're tentatively thinking about asking for an MSI. Immediately I start to think, he has an interest to serve in bringing this matter to an end. I find something like that, a case like that, where I agree with you, a custodial sentence is going to seem unattractive, and they'd much rather wait out the system. That's a case that I would whisper, maybe openly in court, to the prosecutor and say, you might want to consider plea bargaining for this one. Talk to counsel quietly and see what the situation is. Invariably, if a man wants to plead guilty, he's thinking about pleading guilty, he has an interest to serve. He's either tired of the system, he's losing too many days at work, this is hanging over his head, he can't get a clean record, he can't get certain jobs, he's tired. He too is tired. So those are cases that I think are really, really suitable for plea bargaining. And sometimes when you hear the other side talk, you yourself might come away thinking a long custodial term is not necessarily the best recommendation for this case, especially if your victims aren't the best witnesses. But it's not a cookie cutter sort of formula, you know, it doesn't always fit. The other thing I wanted to speak to that you said is very important is I too would be quick to encourage judicial officers who give MSIs to do it in a shorter time frame. If I get a request for an MSI, I guarantee that you will get that indication in less than 2 months. Guarantee you get it in less than 2 months. I can't see what would take me so long. As long as you present me with the agreed facts, by our practice direction, all I need is the agreed facts and the criminal record. That's all I need. I don't need anything else. So the onus is on me. Once I have those two things, what else is preventing me? So in those cases that are taking you that length of time, procedurally, I'm not sure what the hiccup is, but I would encourage you, if it's the agreed facts, settle the facts as quickly as possible, and just let the judge do it.
Agreed. That's why I believe that plea bargaining legislation, we still need it, notwithstanding having the MSI. The two must work in conjunction with each other.
Agreed.
Can I just add, maximum sentence litigation, there needs to be a time limit on there. Maybe the practice direction just needs to be amended.
Yes.
You should never have an MSI going for 2 years. And secondly, MSI is being used a lot more in the OECS, and I suspect that is because the guidelines are in place that makes it a lot easier in order to institute the MSIs.
Very well.
Okay, any other points?
Not at this time.
Okay, thank you very much. Any other persons who want to comment on MSI's plea bargaining? This is the moment. Or any questions for that matter that arose out of the presentation from the judge? There was a lot, there was witnesses and witnesses protection. Happy to invite anyone in the audience, the non-legal persons, to come to the podium or come to the microphone and share with us some of your observations, thoughts.
Chief, would you just permit me to give a few stats?
Sure, please.
2022, where we were hamstrung by COVID and we had a suspension of jury trials and a hesitation generally to do virtual trials. So we were hamstrung in 2022 a little bit. We were coming out of it with more virtual trials. The matters I was able to conclude with the parties were guilty pleas by MSI, and I did 10 of those. Plea bargaining, 36. So many more plea bargain determinations than MSIs. This year, and this is up to May 1st, 15 guilty pleas by MSI and 2 outright guilty pleas. No need for an MSI. I think they really trusted me then. Yeah, so we have about 12 plea bargains in progress right now. So many more by plea bargains than by MSIs, but still an increase. For the plea bargaining process, the legislation is very, very broad. Either party can initiate it. So the prosecutor can approach the defense can approach the prosecutor. But for the prosecutor to begin to engage, they must have the leave of the Director of Public Prosecutions under our legislation. Once they begin engaging the process, the prosecutor has an open, a really broad category of options open to them. They can discontinue offenses against a co-accused. They can discontinue offenses against some members of a family. Imagine there's a raid on a house and every adult is locked up for whatever they find in the house. They can, if they want to, let one person plead guilty and they discontinue against the others within the household. So there's if you incentivize it, it works well. There's some where you can discontinue some of the offenses and take pleas on some. You could recommend a sentence or you could leave it to the court to do the sentencing. But the legislation is fairly clear about the procedure. The court can refuse to accept a plea bargain if it offends against public confidence in the justice system. But generally, the prosecutors do a really, really good job and iron it out. And there's no fetter on what you could, as long as they're pleading to an offense that is disclosed on the facts. That's the real issue there, yeah? And nothing is taboo, nothing at all. I've seen all kinds.
I see Sir Elliott about to rise. I'm happy for that. So we shall. Hold a minute, Justice. I espied senior counsel before I did. I'll say be sure.
This does not relate to what was being discussed, but it deals with...
Get some more volume there, yeah?
It deals with the question of victim impact statements. Is this done as a general rule in Trinidad? Because one of the things that they've found that in relation to young people, particularly in summary courts, where that person is a first offender, it has been found to be very helpful if the victim makes a statement in open court of the effect of the crime on that victim and the victim's family. Invariably, it's not being done, and the accused does not appreciate the impact that his conduct has had upon the victim in it. And the other matter is, I'm told, I don't know, I don't do much practice in the Supreme Court. Here, it is important that even in murder cases where the family should be allowed to give evidence in open court, not in a report to a probation officer. It should be given in open court because the accused must be made to understand the effect of what he has done, not only on society, but more particularly on a person's, the family of the victim. And I would hope that in any new procedure, that becomes a standard thing. If the family wants to refuse it, is one thing, but it should be made available to the family in all cases. That's my short, thank you.
Excellent questions. Our plea bargaining legislation makes it mandatory when the judge is making the checks in the plea agreement hearing to question the prosecutor to find out if the victim was consulted in the process. And as part of the process as well, if the victim would like to make a statement, and that statement could be read by the prosecutor, by the victims themselves, or by a court officer. Any one of the options is available. So it is a part of our process. If Barbados is interested in enacting plea bargaining legislation, I would suggest you scrutinize lots of pieces of legislation, including my own. Look at mine very suspiciously. The provisions in relation to victim impact statement I'm not exactly very fond of. In my own legislation, it needs to be addressed, because within our legislation, the defense have the opportunity to challenge the victim, well, aspects of the victim impact statement, and there are fetters about what could be contained in the victim impact statement. I understand the reason for the fetters, but I always think it's a delicate line when you want to give a victim a voice and then you put a fetter on that voice. It's always very difficult. I think the person who is trained in law ought to know how to excise what is emotive and what can't be applied in the sentencing process. But let the victim speak. Let them just get it off their chest, you know? So it's something to look at. In the MSI process, and this is where the prosecutors have to be sharp with me, if you want to give the victim voice, there's case law that says, coming out of our Court of Appeal, that says the place for the victim impact statement is in assessing, aggravating, and mitigating factors at starting point. If you miss it at starting point, you can't come afterwards and expect it to fit into a guilty plea process. So they have to bring it in there. So I take the point that the harm to the victim, like if there's permanent immobility issues in a chopping, something like that, if the court doesn't hear that, they will not be able to set the appropriate starting point. So they have to bring their victim impact statements early. But remember, you all have been talking about this, and it's in our criminal procedure rules. Give enough information to your witnesses and victims. They must remain a part of the process. Too often, we treat them as passive bystanders until the morning of trial. So you have to keep them included in the process, and that's on the overburdened prosecuting service and the police officers. It's up to them, yeah? Yeah.
Watts, please.
Madam Justice, you had spoken about like as a case list that would have been assigned to your court. You're talking about in the criminal court?
Just repeat the question, I'm sorry.
No, I was inquiring whether you had spoken earlier about a criminal list owning your cases, so to speak, that would have been assigned to your court. And I'm wondering whether you're talking about in the criminal jurisdiction. I understand and experience that in the civil jurisdiction, but not in the criminal.
Exactly so, just like a docket in the civil system. In February of 2019, I got a spreadsheet. Sorry, it wasn't a spreadsheet. I created the spreadsheet for myself. I got a listing of names and case numbers. I didn't even have the charges. Division, name, criminal case number. More than 150 cases. This is yours. Figure it out. And it was pretty tough because prior to that, we used to be assigned to a division, given a courtroom, and you do what comes up from the registry. Now we're responsible, and we still are responsible for scheduling for ourselves, requesting jury pools if we need them, and booking courtrooms, because even courtrooms are a scarce resource. In Tobago, there is only one courtroom that could accommodate jury trials. So only one judge at a time can do a jury trial. So we have to schedule with the others in mind.
Oh, I see. That's not a system that we operate around here. So perhaps that would be food for thought for us here in Barbados.
Yeah. I didn't think it was going to be easy, but we have learned to navigate it, cause the judges to work together and the judges' teams to work together, much more collaboration, because you have a calendar and you have to prepare and get a trial window. It works.
Well, we thank you.
Any other questions from the floor? I invite others to come. Yeah, Billy, yes.
You know, I'm very shy and withdrawn. I don't like to dominate these types of proceedings, and I shy away from the limelight at every chance I get. But, Judge, you had mentioned this thing about I think the Chief Justice giving you a list that would give you an idea vis-a-vis other judges and so on and so forth, where you were. And then in Dominica, at one point I was there was an officer in the magistrate's court who would write down what happened with every case listed that day. And it would be submitted to the judge and to the magistrate and the other magistrates. So that, because I complain quite often, I think magistrates and judges may bear me out in this, more in the magistrate's court, where sometimes the magistrate has a list of 30 cases. And for example, now in District A, where those District A magistrates are being asked to do that work in a 3-hour window or less because they're sharing one courtroom. So they have a court list with 30 names on it, and we all realistically know before we start, no work is being done in 24. So why is the list having 30 names? Why are people coming back every 3 months, for example? And I'm saying all this to say, do you agree that we should have a way of saying, if you have an unproductive list, you're mismanaging your court? If you have a list that has 30 people on it on a day in the magistrate's court, you self know you can't do it. And you know that 24 of those cases getting adjourned. So yes, we want to appear to be doing a lot. But if somebody was writing down and showing you at the end of every day, you had 30 cases listed today, 24 were adjourned with nothing happening. The prosecutor gets to his feet and says, date please. Date given, case gone. So I'm not saying that we need to embarrass each other into getting the work done. But at the same time, we got to have lists that are realistic in the context of the realities. Now, if I go to St. Joseph at 3 o'clock, I know that my learned friend, the magistrate Douglas Frederick, will be on the bench and will be available to me, even if his work for the day is done. But in town now, town park, town like Port of Spain, right? We got a lot of work to get through, but right now the 2 busiest courts in Barbados are sharing a space, like roommates. And each of them with a list of 30 cases. It can't be done. So we got to make up our minds how best we approach that.
Yeah, I think if you'd allow me to treat with them as 2 separate issues. One, the performance standard aspect of it, where we got the anonymized statistics from the Chief Justice. That was more for our own self-assessment. You internally self-check. Now, there are judges, some of my colleagues, they may see that for the month of X, they had only 1 determined case, whereas another judge may have had 5 and another judge 10. But this judge is quite comfortable with that 1 that they had because it was a heavy murder. So it's relative in terms of the worth of it, yeah? It's a separate issue. The other issue you're speaking about is those very heavy lists and how productive can you be with a heavy list that ends up being what Jamaica used to call their mention lists, where you really just come to get another date. There was a time in Trinidad where if you were in custody, you were required to return to court every 10 days. They changed that to every 28 days. But still, all it was an attempt to was just to clog the list with repeated just remand dates, and those are very heavy. It used to take place all over. It's a very challenging issue without the manpower available, but I hear you about plant as well being an issue. What has worked, COVID was, how can I say, you don't waste a good crisis. COVID helped us in a sense, in that our virtual capacity helped us to see that court does not have to be a brick and mortar consideration. So that by having virtual court spaces, many more district court judges, because we did change the name of our summary courts, judicial officers, they are not magistrates, they are district court judges, and my friend Carlisle was correct. Everybody dropped the district court, and we call them judges now. But they are district court judges. The district court judges now sit virtually, and it's also easy for the attorneys in a very small bar to appear in this district court in the morning, and then appear in another district court before midday, and then appear in the high court in the afternoon in a civil case or even in a family case. So perhaps enhancing your virtual capacity is part of the solution to dealing with those clogs in the lists. It might help. That's my suggestion. Yeah.
Thank you very much, Justice. I saw Justice Graves. Just hold a minute, Carol. I'm going to give you some batting time. But there is someone. Could you identify yourself, sir?
Owen Birch, probation officer.
Thank you, Owen. You may speak.
All right. As we're speaking on the efficiency within the system, we're going back to the victim impact statement. What we are finding in probation department is that a lot of times where high court matters come to our attention, the information, contact information for the victim is not being submitted to our department. So when we do our general investigations up front, then we are having to wait extended periods to get in contact with the victim or the relatives, and that is causing us then a delay in producing the reports on time. Thank you.
Thank you. Justice Graves, are you ready? I remember you had finished a very important point just before the break, and how many more points do you have there?
I don't want to scare you again, but several of those points are short and can be put together. I just want to finish off just a little piece on that.
Hold a minute, Carol. Hold 1 second, please. Hold 1 second.
Lord have mercy. It's going to happen again.
Hold a minute, Carol. There was an issue which was just raised by Mr. Birch. Where is Mr. Birch?
Birch?
Yeah.
Was it Mr. Birch?
How can your, not Justice Christopher, the other Birch. How can that problem be resolved, sir?
I believe that once the requests come from the court, when that request comes into the probation department, once the victim's information is there in terms of contact information, we are then in a better position to go forward with our reports. As I said, a lot of the time when the request comes, it doesn't have contact numbers and so on for the surviving family. I will speak about one case up to last week that we had, and I actually contacted the DPP office requesting information on the victim, and what I got back was the person lived in this area. That was it. And basically then I had to use my own initiative to contact some person that live in the community to ask if they knew of the deceased. And in that way, that was how I got to get the information from the brother then of the victim.
Yeah, but a lot of things there that is wasted. How do you see who should be sending you that information? I just want to understand. It seems to be an administrative matter.
I believe the clerks of the court, along with the requests, that information should come with the requests.
I'm going to invite the deputy DPP or acting DPP to make a comment here. Yeah.
Yes, I think sometimes this thing is a little problematic. It may seem simple, but when an offense occurs, sometimes a complainant lives at a particular address. The police will take that address, they will have it on the file, that is the file that comes to me. By the time that matter comes to trial, the address I have, even to get the witnesses to come to court, we can't find them because they've changed address, they haven't told anyone, and then I have Inspector Ford working in the court liaison office trying to find where that person now resides. So even though my friend alluded to the fact that calling the DPP office and we gave him an area, that's possible because we've got an old file with an old address and everything old, and we can't really find these people based on the statement that we have. So it is not as simple as saying that, you know, it's easy to find the person's their address there. Many people move between offense and trial date.
Okay. Well, I think whatever has to happen, the probation office must be facilitated to make the job much easier.
Yes, exactly.
Because both the judges and defense lawyers complain about the delay in having the reports ready.
Yes, sir.
Yeah.
There's just one short thing I want to say, though, just briefly. Now we're talking procedural. I don't hope to be long, but something as simple, and we, the players in it, know it every day, but it may seem, you know, trite to some. Something as simple as a date you can lose, and right now we're talking about backlog, and I would like to see it in any criminal procedure rules. When a holiday, an unexpected holiday falls on a day, it can offset a whole court. So what we have, sometimes we tell an accused man is supposed to turn up for court on a particular date. A government wins election and declares a holiday, for example, unscheduled. No, it don't happen often. Ashfall happens. Ashfall happens. Sometimes hurricanes about to approach, something like that. And something happens and we don't get court. Now, it's not in the interest of accused man to find himself back to court, and that's the problem we get. So it is how do we find him again? And I would honestly like to see in any legislation that when a holiday falls on one of those unscheduled dates, that the accused should present himself on the next date. That it be, and that's the way, because sometimes we look for a whole day calendar, maybe 40 matters. We have to look for a number of these people all over again because a holiday came into place. And that's something simple. I want to talk about judge only, but I don't want to hog the mic.
Go ahead, because Judge only is going to come up. Let Judge Graves raise it, and then I'll invite you. So, Justice Graves, the floor is open to you. Remember, we are hoping to close by 5, so you said you are good in the law order. You know how to make 25 runs off a few deliveries.
Is there a perception that I bat long?
Yes.
As I said earlier, I'm a tail ender. I'm good for 10 runs in a century. Okay, so before I get there, the question, issue put by Andrew, I could answer that for you. And the one put by Justice Watts, I could answer that for you. And the one raised by my friend, Mr. Seals, but I'm going to focus on my stuff first, and then if you have time, you can come back to that, right? When I last spoke, I just wanted to wind up before my concentration was broken, to say for my argument for the upliftment of status to the magistrates, to summary judges, et cetera, I think is emphasized by this fact that I would argue that they are as qualified to try the high court type cases in criminal cases as high court judges are. And in some cases, they're even more experienced than the high court judges are when it comes to the trial of matters. And in particular, this is in support of my argument that if you're considering the judge alone trials, that the priority should be given to transferring those matters there for them to try them. And just one little piece to add to that is my argument is not only in respect of criminal cases, but also in respect of civil cases. A motor car now costs $100,000, $120,000. Magistrates can deal with all that kind of stuff down there instead of filing suits in the Supreme Court up there. And since we've transferred much the old preliminary inquiries and so on from them and removed them, it means that there must be an argument that space is left to increase their jurisdictions in respect of other matters, because that formed a substantial part of their work in the past, and that has been taken away and not replaced with anything. Now, recommendation 2, the court service process. I would invite some reform of that. When it comes to summonses, we are still dwelling in the old system with marshals having to go out, hiding in the bushes and all kinds of stuff like that to serve summonses on people who don't want to be served, or who, as Mr. Seal said, this will help to answer your question, have changed their addresses and so on and are not able to be found. The recent COVID crisis taught us something about ourselves, about innovation. Everybody who had a COVID test got his results how? Electronically. By what? Email. I cannot see how in this modern time that we wouldn't be having legislation that says that you may be served by email, and when that is served, it is deemed to be served. Under our present system, the marshals have to return an affidavit of service. And very often that does not get back either at all or in time. And judges are frustrated over and over because they have to reissue the process. So we have to get modern. This is the modern era of electronics and different types of communication. The young people move all around the place, but they're on social media all the time. So maybe our legislation should provide for this type of modern service. When I went to but the judges are supporting, right? When I went to the COVID office with my mother, she had no old address. She's about 188. So she wouldn't know anything about email, but she provided one, which was whose? Mine. So even if you're old and don't use the media, you would now provide the police, for example, when they interview you, or whatever the case is, whoever else interview you, with an address which may not be yours, but somebody who's close, and the legislation may consider that to be deemed. There you go, right? So that's one. As part of that, I would suggest that you consider reform of the Evidence Act in relation to the voir dire. All of these I'm dealing with the wastage of time, all right? A lot of cases, the backlog comes about because one of the reasons it comes about is because of the wastage of court time. So when I came to Barbados to preside on the court, I was informed by the judges, one of the judges early, that this is voir dire country. So every case has a voir dire, or 2 or 3. For the 12 or 13 or 14 years that I spent on another bench in another place, I probably, if I say that I did more than 2 voir dires, I think I might be exaggerating. I have no recollection of doing more than 2 voir dires in that case, whether it was a voir dire dealing with a confession statement, or whether it was a voir dire dealing with the issue of identification or something like that, right? And there are reasons why we cut out that. Now, under the present legislation in Barbados, it needs to be clarified. I think it is not clear if a voir dire, let's say on the admissibility of a confession statement, can be done in the absence, can be done in the presence of the jury. In my view, when I read that legislation, it is not clear to me. And I think it needs to be clarified so that if we are going to be doing voir dires, we can do them certainly a Joda style. And you lawyers know what I mean by a Joda style, which means you do it in front of a jury and then make a ruling at some point. 3, consider amending the Juries Act. I've raised this issue at other places. I think the Law Reform Commission is probably aware of this. But I would like to see the Juries Act amended so that it may bring about more justice to those who need justice. Now, that may include amendment of the Offenses Against the Person Act to provide for included offenses when we are trying murder indictments, but not included offenses, but other offenses. We have a situation in Barbados now, for example, as illustrated by a recent case, for example, where a man may stalk a woman, for example, abduct her, rape her, and murder her, and may even launder her goods. The only charge he will face before the courts and be convicted for is the murder. Certainly this cannot be justice. So let's say that he is convicted. 15 years later, he gets out. And he kills again, or rapes again, or something like that. The only record the judge who is now going to sentence him would have before him is that he's convicted for murder. Because he's not going to have any history of the other factors that led up to the murder. The rape, the stalking, the abduction, or anything like that. Now, we know that the problem with trying these offenses together happens to do with the different numbers that you require for the different types of offenses. I hope that with speed, we would move to make the requisite amendments so that justice is not only done, but is seen to be done. That record should indicate the offenses that he committed.
Caroline, let me So question, are there too many persons excluded from jury trial? There are some persons who are designated as not being capable or not being authorized to sit on juries. Have you ever looked at that section of the Juries Act?
That's not on my list today. That would add on 15, and I don't think you're going to like that. So I'll let somebody else deal with that.
Yeah, I think Alistair will talk about
somebody else can deal with that,
Yeah.
let me come back.
Right.
Number 4 dropped off the thing, so I'm not going to be able to deal with that unless it comes back to memory. So I'm going to go to Reform 5. Consider reforming the committal system some more. Somebody else raised this earlier, so I don't think I need to get into it a lot. But the system as it is has not worked as well as we thought it would be when everybody seemed to have felt that the abolition of the long-form preliminary inquiry was going to solve all of our problems. Something I warned about, not only here but other places, that it would not. So I would suggest a system such as another jurisdiction, let me call Bermuda, for example. They have a system called a sending system, which they copied from a distillation of the British Criminal Procedure Act. I've heard about new criminal procedure rules, and they looked at different jurisdictions, including Belize, that we're going to look at now. But I think there can be some help that we may find also in the UK system as well. And they have a system that we call, where they have a sending system. That is, once the person is charged, they're charged before the magistrate's court. And without any consideration of anything, including any papers, the magistrate sends it to the Supreme Court if it's an indictable matter. That's what it's called, send. So he sends it. By the time it gets there, the DPP has the papers and so on from the different agencies and is able to form an indictment also. And that helps us. Now, when it gets there, there's something that we call a Section 38 hearing, which is a sufficiency of evidence hearing. And before the person pleads or is arraigned, counsel is entitled to make an application to the judge to make a ruling as to whether there is a sufficiency of evidence. That speeds up the process tremendously. It puts a lot of pressure where the pressure is on the DPP's office to ensure that they get the papers and the indictments done, and the DPP in turn puts the pressure directly on the police. Nobody listens to a little prosecutor in the magistrate's court who's making noise with the police hierarchy. He himself being a police, and he's making noise with the police to produce papers, but certainly you would listen to the DPP in those circumstances. I would suggest that you consider the system, not saying you must have it, but consider the system. You might find that it might speed up the process. 6.
The sufficiency hearing is held before the judge who will ultimately have conduct of the trial?
Yes.
Okay.
Yes. And it's very quick. On arraignment day, I would sometimes do them. My argument used to be in the case where they would come and would say, if you have enough to bring him before the court, Mr. Prosecutor, you must have enough to be able to argue whether we have a sufficiency of evidence to put him to trial. Mr. Defense, if you have enough that you can make an application for a sufficiency hearing, you must know your case, so you must be ready to argue. And I would dispose 10 of those or so in the afternoon or morning after arraignment or something like that. It is not as easy for some other judges. I know some judges took 9 months to be able to make a ruling like that because they wanted everything in writing. Very often I would sit down and let's look at the file. You refer to the particular area in the file that you want to refer to. I would take note mentally. Sometimes I take a little jot, and I'm able to make a ruling 9 out of 10 times or more instantly. That's a simple process. All right. 6.
I just want to be sure that we are not transferring any backlog issues from the magistrate's court.
But we'd be transferring it right belong. That happens. I would admit that that happens.
Okay.
I'm going to come to deal with that if I deal with these new rules. But since you've raised that issue, I want to say this. Everybody is harping about we want new criminal procedure rules and so on. Just like we harped when we were harping for the abolition of the long-form preliminary inquiry as if it was going to solve a problem. And for the introduction of the short-form preliminary inquiry, otherwise known as the paper committal, as if it is going to be the healer of all things. It did not. There is no country I know outside of Singapore that has criminal procedure rules that is not backlogged. Furthermore, add this, that is not severely backlogged. So it's not rules that solve your problems, you know. Very often it has to do with personalities. Whether your holes are filled with the proper plugs or the plugs are square. All right? So you will get some backlog. This has happened in Bermuda, for example. I must confess this. Let me make, since we're on that point, let me say this. Before we introduced the new Criminal Procedure Act and Criminal Procedure Rules in Bermuda, we had 10 or 12 years of no backlog under a simple system devised by my Chief Justice and me. No backlog. That means we could try any case, we guaranteed every case, a trial within 3 months from the date it was first brought into the Supreme Court, which is usually for arraignment. And 6 months at the worst. You have to give exceptional reasons not to have your trial fixed within that 6 months period, and good reasons not to have it fixed within the 3 months period. Then we introduce these fancy criminal procedure rules. Without any consultation, to tell the truth, with the criminal bench, they were brought and put upon us by an Englishman. And we wound up with a backlog. I left Bermuda I first retired in 2015. I left only 3 cases to be tried. Only 3. I retired as supervisor of the criminal division on that date and came home. Went back part-time for 3 years, working 6 months a year at my choice. When I left in 2019, there was not a single murder committed under the system that we had. We had pushed that down into the ground. But there was a creeping backlog under the new supervision. It wasn't major. Today, with all those rules, we are so majorly backlogged over there that they're trying to send a summons for me, which I will not answer. I'm home for good. So let's come down to the, but it's still a better system if you use the sections 38 and the sentencing provision. Than I had predicted that the new sentencing, one of the problems with the criminal procedure rules is that they have these times that you have to meet, as Justice Hines was referring to earlier. You have to meet these times. You have to serve your indictment by so-and-so, serve your the disclosure by so-and-so date, then the defense has to serve this, and all that kind of stuff. You have these time limits that are supposed to culminate at 90 days. When by then, the defense, the prosecution is supposed to serve a readiness for trial stuff, and the defense is supposed to serve their defense, all right? But you have used up 90 days, and you now have to look to set a trial date. Under my system, we set a trial date the first day you came, on the arraignment system. That's the system we now put here under our new practice direction here, all right? And what happens then is during those 90 days, I might set a trial at 90 days down the road, all right? And during that 90 days, through a series of case management and mentions and so on, you are able to work towards that date. So you have the date and everybody knows that you have to work towards the date. Rather than the other way, you have all these time things like the old civil procedure rules, and then at the end, then you look for a trial date. All right, so that helps to cut out that. Let's go ahead. Number 6, consider some reform to the legal aid system. Under the present regime, and the law as lawyers interpret it, they believe that defendants have a right to choose whatever lawyer they want to choose. That's the basic principle. You have a right to counsel of your choice is a basic principle. And you go to the legal aid and you pick whatever law you want. So under the system, we pick the people. This is how the criminal systems work everywhere. People will select when they are in trouble. They're going to call the name of the lawyers that they hear about all the time. So the same 6 lawyers get selected all the time. And what happens, it winds up that the lawyers run the courts because they are not available to suit the period. So we have to amend the legal, even when the judge certifies, makes a certification for legal aid certificate, this thing still happens. I propose, in fact, this is my policy since the last symposium we had, the last day. I now amend that. The court of appeal can fix me whether they want to or not. When the time comes, I don't know if I'm right or if I'm wrong, but this is what I'm doing. I now make an order in my certifications that that counsel, that defendant, particularly since it's at the government's expense, he's getting legal aid, may select a lawyer of his choice, providing that lawyer is available for the date fixed by the court for the trial. And that lawyer may only accept the brief if he is available and declares to the legal aid that he is available for that day. The idea is to eliminate the power of the lawyers to come into court, know they're not ready, but take the case. I don't know if it's because they needed money or the fame or the practice, but come and the first thing they want to do is ask for an adjournment. Sir Clifford Husbands, when I was a young counsel, always said this from his bench. Your right is a right to select the lawyer of your choice, providing he's available. And he always said this to the lawyers. When you accept a brief, particularly when it has a trial date, you accept it only under the condition that you are ready to proceed. He always said, when you enter appearance in this court, you enter appearance to proceed, not to adjourn. This is not an adjournment court. All right? This would have given me the opportunity to answer the question earlier put, I think by Sir Pilgrim. He'll be a sir eventually. About the problem the magistrates had or have with the 30 cases on the list every day. There are some magistrates here who know the system that I implemented back in the 90s when I was there. We didn't have that problem. We eliminated that problem. But if you want me to talk about that, that'll be later, not on this list, because I want to get through these things. Number 7, the transfer of files from the police to the courts, that needs to be reformed. I'm going to tie up this on my number 12 when I come to deal with that. But that needs to be reformed. This constitutes a tremendous delay and a substantial amount of frustration to both the magistrates' courts and to the Supreme Court. It feeds into that problem we have of those many persons who are in prison who want to plead guilty, for example. And we can't get enough information from the police that the DPP can sign an indictment so we can take a simple plea. If we can't do it when a man is saying guilty, can you imagine how big the problem must be for us when he wants to go to trial? It is probably 10 times worse. Since I am done that, I am going to take a little dig but support for my police friends. One of the problems we have here that helps to delay the courts a lot is delay caused by the non-disclosure of the police diary, station diary. Very often, the practice in Barbados was that the lawyers would wait until they come to court for the trial, and some officer from the police would bring the station diary down there, and they would go around the corner and try to read it and come back. If I have ever seen malpractice in my life, that is malpractice. No lawyer is good enough to defend any defendant having just peeped at a station diary that the police just brought and given in the midst of the trial. The diaries must be disclosed early, as they are relevant, particularly in serious cases, to the defendants. And they must be attached to the file and disclosed without request. I introduced a system since I came that they must make photocopies of the relevant and give it to the lawyers so that they can test. And the first case we did it in, it worked so well for the defense that they were happy to have the case thrown out at halftime. I'm not suggesting that you help them out that kind of way, but that's what happened. Now, I want to say this about the police, some more about the police diary. This is the modern era. It cannot make sense that a policeman is sitting down writing a diary in longhand in an old book that gets stored or lost after, but the police get rid of it in 5 years or something like that, right? Puts in some more room and you can't find it in their system in Barbados, where men are not getting trials for 10 years. It doesn't make sense. It seems to me that everybody has a computer. So you should be entering that data in a properly computerized diary, which has a backup system so that the police officer who put it can't change it and be accused like they are now of rubbing it out and putting it back. It makes sense, therefore, that all you have to do then is to put in the name, the data for the person in the computer system. The thing spits out the data in relation to that defender, and you have your disclosure in a hurry. This might mean spending a bit of money to do it, but this is a reform that, in my opinion, is urgent. And if it needs legislation to bring that about, that is urgent and ought to be done, so that you would not waste my time doing mention after mention after mention in order to get the file disclosed, and in the end, I get evidence it hasn't been found because we moved from Hastings to Hastings Worthings, and all of those files get lost, and all that kind of thing, and the jury doesn't believe you anyhow. They feel you're hiding something. Come to number 8. Police would like this. I'm not going to be too long on it. In fact, I'm not going to be long at all. But the investigation process has to be improved. We've talked about this before. It can't be just confessions, whether by oral or writing anymore. That has to go. Right? The present system leads to unnecessary trials. When an investigation is tight with good evidence, counsel are better able to advise clients, and often you will get more guilty pleas from those who are guilty and know they're guilty. No, I'm not advocating guilty pleas just willy-nilly, only from the guilty ones, should they come. Laura Bingham, as I heard earlier, quoted earlier, said the guilty should be convicted and the innocent should be acquitted. And we should not, in modern times, be relying on artificial technical rules to frustrate the courts of justice. Now, the other 9 matters, the other 3 matters, or 4, I can put under one thing. That is introduction of the PACE codes from England, not just the PACE Act, but the PACE codes, Police and Criminal Evidence Act, in particular, Code D, which deals with video ID parades. Video IDs, also known as PROMAT. I've spoken to the police about this before. I am not sure that we have such a system here. And the audio, video recording of confession statements, a form of which we have here. Now I have to deal with that, both of them. Let me start with the PROMAT ID system that we dearly, dearly need. Some of you might remember some years ago, there was a series of robberies or burglaries on the South Coast. I think one of the lawyers, or prominent lawyers, I believe, was said to be a victim of one of them. And it was said that the person was a Spanish-looking kind of person. But just imagine if he was a Spanish-looking person, or he was a Malaysian, or an Egyptian, or a Filipino. And we had to hold an identification parade under this old system that we have in relation to him. Tell me where in Barbados you're going to find 8 or 10 Malaysian-looking people to hold an ID, or an Egyptian. Whatever you do, the first challenge by counsel is that is an unfair ID parade. And I have to hold a big, long voir dire to deal with that issue. And I don't know that you come up with a proper decision. Under the PROMAT system, it is a computerized system which has a data bank of millions of photographs of every race, creed, and color. If the robber, for example, was a man from was a man from in the middle of the Amazon who Mr. Bolsonaro never seen in his life. That's right. They have photos of those too. If he's a Maasai across the Serengeti, they have photos of that too. And what they do is they take a picture of the suspect, and that feeds in to the computer system, and the computer system at random selects people like that. It spits out then about, you can decide how much parades you want to put up, but it spits out a photograph of, which we call a parade. And you can get, let's say, 10 parades. Each time he is in a different position. And he is given a opportunity in the presence of his counsel or other representative to select which of those parades he wished the witness to see or the witnesses to see. And then the witness enters into a separate room, looks at the parade put up there, projected on there, and selects the person. Number 2, you may have a case of 6 witnesses who feel that they can identify the person. He's given the opportunity to say, well, witness number 2 is going to come now. Do you wish to see him parade or you want a different parade? He said, no, boy, I ain't going back in that number 2 position. He might pick me again or talk to the person out there. So he picks the position now that he's at number 6. And they see that parade and pick it. And it goes on and go on. I don't think I need to explain that any further. And every step is signed for and signed for by form. That's why the Code D, PACE rules in England are important for us to adopt along with the appropriate legislation. Right? Too much chat, man. Just give me a minute. I can finish now. Those are 3 points just added. That can put me down to just the final on that same point is this. The confession statement we now have that give us so much trouble, even though now it is recorded on the video in some cases. Reform it. You must change the provisions in the Evidence Act to simplify it and bring it into a more modern space. Under the present Evidence Act, it appears to me that it was drafted at a time when our heads were stuck into the old practice we had of written statements by the police, who usually say they tell the man he can write it himself or have someone write it for him. He say, you write it. So the system is set up, the camera system is set up to verify that the police took a written statement. It takes forever. Very often you cannot even see properly the defendant or suspect who is giving the evidence because the camera is merely focused on the police officer writing the statement. You have to ask them and write them down and write them down. So when you come to instruct the jury, you're telling the jury that the confession statement you see written is the statement, not the video. I say change that because it is bad in law, it's bad in practice, it wastes a lot of time by the police, and it wastes a lot of time by the courts. This is how the system should be, and this is how the legislation should be, and this is what you will find in Queensland, Australia, and you will find in Bermuda, for example, where I've practiced the system for a long time. The true evidence of a confession statement, or statement given to the police, must be the audio video. So there is no necessity, it is not necessary for the police to write a written statement. Okay? What happens is once that video audio is created, the police or some technical people associated with them will create a transcript which is numbered down the side, every line or every other line. It identifies the parties as they speak, and it has a page number at the bottom. It is only an aid to the true evidence. You can see why it is an aid, because it is somebody's opinion of what they heard or think they heard the person say. So in that case, then the judge would instruct the jury, as I just said, this is an aid. The true evidence is the audio, video that you see here, so you should listen to that carefully. People hear sometimes the same things different ways and see them different ways. So what the jury hears or there on that is what he would decide the evidence is. It is faster, it is more accurate, the police can get him more in it, the man flows, and in addition to that, the judge has to instruct the jury that they should take into account the context in which the questions are put, the context in which they're answered, and the demeanor of the man. So this fellow who comes in there and says he'd been beaten to oblivion, he was in so much pain when he gave his written statement, how is he going to say that? When I am telling you the evidence is on the audio video, and he's there sitting down laughing with the police, volunteering and talking and all kind of stuff. This, the police are getting a chair for the police or not? Oh, man, you fellas stingy.
Justice, you have about 3 more minutes to wrap.
And I'm going to make it. Yeah. So that should be changed. Now I come to the final, 13. The reality is this. Whenever we hear the words backlog, one thing comes to our mind. Blame the judges. Blame the courts. Nobody, you will not hear a debate in which they will say, blame the police for not producing the files. Blame the DPP for not signing the indictments, registering them, or if signed them or not, bring them to court at our arraignment session every first working week of the month and have them arraigned so we know where we're going, have a date set. You wouldn't hear that. You wouldn't hear anybody say blame the marshals who didn't serve the process and return the affidavit. None of those things you will hear. It is always the judges, because we are miseducated or misinformed. And even us who work in the system say blame the judges. And that's why you wind up with things like an amendment to the Constitution that says get rid of them. If they don't send back a judgment or whatever case in 6 months. I mean, that's out on the civil side mostly. But it's part of the feeding into the sentiment of blame the judges. Some of us can't take any criticism who work in this judicial system. Whether it is the judges themselves, that they're skin too thin to take a criticism, or up at the DPP's office, who can't take a criticism from a judge, or out at the police, who can't take a criticism, think that people are attacking them, or we can go on and go on. But the point is that we all constitute component parts of the judicial system. Some have said, even in this symposium, that we should not be heard criticizing anybody. Can't criticize the lawyers, can't criticize the prosecutions. Somebody said that. I disagree with that. Courts are in the business of criticism, but they are also in the business of offering solutions. One should never criticize without offering a solution. And to close, I quote Lord Atkins in his seminal dicta in the Trinidadian case, Privy Council case of Omar and the Queen, 1935, 36. I think it was, I got Omar, I'm barred and the Queen. I'm barred, what's wrong with me, man? Getting funny. And he said this: justice is not a cloistered virtue. She must be allowed to suffer the scrutiny and respectful, even though outspoken comments of ordinary man. And I take that to apply to everybody. And then I refer to the Chief Justice, the former Chief Justice of Delhi and the Madras High Courts, who said this. His name is kind of thing, so I didn't even write down his name. He was the former chairperson also of the Law Commission of India. And he wrote an article in which he was dealing with the issue of a judge who clashed with the rest of the judiciary. And he supported that judge in his argument. And he said this: the assumption that respect for the judiciary can be won by shielding judges, my words I'm going to add, and the other agencies who participate in the system, from criticism, misjudges public opinion. Surely, an enforced silence in the name of preserving the dignity of the judiciary would cause resentment, suspicion, and contempt more than it would enhance respect. A mature and broad-shouldered approach to criticism can only inspire public confidence, not denigrate the judiciary. For justice, as Lord Atkins said, is no cloistered virtue. So if anybody feels that I am critical of you, I'm only trying. If anybody feels that we should not say what we have said and what I've said today, then perhaps we should not be at this symposium, because we are examining ourselves. We are not going to take then the recommendations that the CCJ so often makes when it tells us about ourselves. Therefore, I adhere to these principles, and I plead guilty. I hope that you adhere to them too, but you do not have to. Thank you.
Thank you, Justice Graves. I'm going to invite, I see Sir Elliott moving to the microphone, but I'm going to invite the police to give some responses because there are one.
I'm not going to be very long with you.
Yeah, one of the key players or what? One of the participants
Yes, and I would
in the
like,
system.
I don't mind them coming. I would prefer them to come after me because I'm going to say one or two things.
Okay.
I am not here to be critical of anybody. For that matter, I have every right, if I wanted to be critical of anybody. I am a practitioner of 61 years. And I know the days in Barbados when we started court at 9 o'clock, in the days prior to ladies sitting on the jury, and because the men had to be, the jury could not go home, and the men had to stay at the YMCA on cots. And it was only because it was found that that would create an indignity for women that juries were allowed to go home. I'm not going to start there, though. I want to start because I want to say something. I thought that in all the things that Mr. Justice Graves said, that he would have told you the hours that he worked as a judge in Bermuda. And I'm glad he ended where he did by saying justice is not a cloistered virtue. I took the job in Bermuda as Attorney General on the understanding that I would prosecute all the murder cases in Bermuda. And that I did. I started at 9 o'clock in the morning, worked until 12:30, and worked from 2 to 4:30. Like any other public servant, I did that as Attorney General of Bermuda. Now, we talk, a young guy came to see me twice last week. He told me he was on the jury, and I didn't get involved in whatever matter, whatever case it was. The second day he came to see me, he said, and this is the observation of a juryman, not a lawyer, that by 12 o'clock that day, 4 Supreme Courts doing criminal work had finished for the day. When we speak, and Justice Graves wants to know about blame for judges, at the end of the day, whatever you say, the judge is in charge of the entire criminal process. And all the criticisms he makes about the DPP, all the criticisms he makes about the private lawyers not turning up, and the probation office, the judge has it within himself to use his power as a judicial officer to sanction all of that. And as soon as he does it, you will see how quickly it will stop. So long as it remains unsanctioned, we will continue to have delays. But if and when it happens that the judge takes upon himself or herself to sanction the conduct of those persons who fall below in the in the criminal justice hierarchy, then all that goes on now will stop. I am not going to stand here and criticize. It's easy to criticize a lot of people. I don't know how long it takes the police to record a statement. I look at criminal trials in this way, the investigative part of it. I do not know how long it takes to prepare a file. I would hope when the police respond, they will tell you the procedure that they use. Do they still take statements by longhand? Do they still rely on taking evidence and sending it to the forensic pathology? Or should we now, in the 21st or 21st century, be having people who work within the forensic pathology attend the scene of murder cases, attend the scene of rape cases, and they'll carry out, as part of the investigative arm of the police, carry out their investigations. How many people in Barbados can tell you what blood spatters? If you don't train them, nobody will be able to do it. If you have a system where the forensic lab is closed, I don't know for how many years, if that is closed, 3, you can't come. Longer than that. Anyhow, the point is that you cannot have systems where one part of the system falls down or fails because it is going to be reflected right throughout the system. I don't know how long it takes the police, and I hope when they come to tell you what the procedure is. 1, tell you what the existing procedure is and tell you what they would like to achieve out of this. I have ideas on it, but I am not a police officer. I am not involved in the investigation. And I would hope that, coming as they are now, let them put forward. And I listened to the Prime Minister. I always listen to her, actually. But I listened to her today, and it is clear that the whole question of criminal trials in this country is at the forefront of this government's responsibility. Actually, I wasn't going to say anything about that because I was sitting there at the table with a lot of politicians. I'm not a politician. I ceased that in 1976. But the point is that the time is ripe. You cannot, as Justice Graves said, even when I was doing criminal law so many years ago, there was always the complaint that every conviction, or most convictions by the police force, based on a confession. And Sir Dighton Ward used to tell the jury, when the only evidence against a man is a confession, that the evidence must be like Caesar's wife, beyond reproach. But that has changed. There are too many, sometimes the police don't use what they have collected. You get a confession. A confession in itself should not be the end of the case. Use your confession to build the case against that accused person and see what he says and try all of that. Now, the recording of statements, the production of those statements into files, because in this day and age, the file that goes to the Director of Public Prosecution, a similar file should go to defense lawyers. I don't know if many people appreciate that there's a practice direction by Sir Dennis Williams back in 1986, I think it was, when they started paper committees, when he was Chief Justice. He made a direction in relation to that. And the only thing that should be excluded from that file, as it was in Bermuda, was that any statements that privilege, like statements by police informants, was the only thing that should have been excluded from that file. Other than that, all statements should go and be served on not merely the persons who the prosecutor wants to call or the police want to call. Every single evidence, every single witness. It used to be submitted as unused material, that they'd never used it. And it should go to the defense lawyers. Now, I don't know how long it will take the police to produce that evidence, because in the old days, and I say old days, I don't even know if they still do this, they used to have to take the statement by longhand, and then you had to type it. Now, that should not be in a day. I heard the Prime Minister again spoke earlier about various things. The ministry, and I'm sorry they're not here, the Ministry of Innovation, or whatever it's called, should be part and parcel of this discussion. They should be telling us what is available for transforming evidence. How, again, I go back to the Prime Minister. She demonstrated by using the phone and said, I can do this. But that's oversimplification. But we need to know from the Ministry of Technology what systems are available. Barbados is a small country, but in the 21st century, what systems are available for the recording and transcribing of statements from witnesses? Because I believe, I'm told, that in England, you have to get certain cases within a given time. So to do that, you must have the proper technology, and perhaps the police can tell us what they have and what they identify as required. I'm not here to criticize the police and tell everybody everybody in this country, as Justice Graves is responsible for the slowness of things. But what we need to know is what is required by the police to improve their investigations and to improve their system of evidence. I agree with Justice Graves that the time has come. It is almost 40 years ago that PACE was passed in England. PACE can't be that bad. And we would, like every other piece of legislation in this country, except one or two things in civil law, every single thing is generated out of England. And it is unfortunate. Only when you look at the 1998 Criminal Procedure Rules, there is a statement that says that the law in Barbados is the substantive law, criminal law. But the procedure, and I don't know that my friend, the Deputy Director, or any of the lawyers appreciate this, that the procedure to be followed under the enactment of 1998 is the English procedure. That is what is required. I don't know that they follow it, but that is what the law says. So that the second part of it is the question of the, you investigate it, you make an arrest, how do you treat that person when he's arrested? The third and final part of it is the whole question of preparation of case for the Supreme Court. I don't agree with Mr. Justice Graves, but then it is important that people disagree. You have to abolish completely the preliminary inquiries. You have to establish, and this is what I thought was failing in this conference, to identify the methods that are the method that is required for the trial of cases in the Supreme Court, indictable cases. You need to have a sufficiency hearing. In Turks and Caicos, that sufficiency hearing was done by a judge. That is not going to be practical in Barbados because of the number of cases that judges have to do. And therefore, it will be necessary to have two masters. My recommendation would be to have two masters, criminal masters two masters dealing with, I shouldn't say criminal masters, two masters dealing with criminal cases alone. And you set out in detail, as is done in some jurisdictions, what the jurisdiction of the master is. And as Madam Justice said earlier, he would have the equivalent jurisdiction to a judge of chambers, which would be the same as the civil cases. The point is that you go before him. He does this sufficiency hearing, not a judge. Don't take time. Why should a judge be doing a sufficiency hearing when he got all cases to hear? And the DPP has a lot of people in his office who can send to people before a judge or before a master to say whether the evidence that he has produced is sufficient in order to bring a case. Then we go further. And this is the last point I'm going to make.
Thank you.
One of the last things, and one reform that is needed, and I hear I'm going to call him Carlisle. Carlisle say he only had 2 voir dires. When I prosecuted, and each murder case, I think I did 13 murder cases in Bermuda prosecuting, and each one had a voir dire. Each and every one had a voir dire in it. Now, I did case here once that took me 15 days to do, but I had the jury out for 6 days on a stretch. They used to come in and go out, come back at lunchtime, come back for break, go back out. That is a waste of manpower. The economy of this country can't afford that. So what I would recommend is that at the plea and direction stage, if the man intends to say plead guilty, then that he's go on, there will be provisions for that. But at that stage, when he's before a master, he should indicate that I am going to challenge the evidence as not being free and voluntarily. And therefore, when that matter goes before the judge, it goes with a note saying that there is going to be a voir dire on the confession statement. Now, this is a simple procedure that I would recommend. You don't need to have a jury sworn for voir dire. I disagree with Carlisle on this because admissibility has always been a question for a judge. Where is a question for the jury? And therefore, at that stage, all you need to do is to say, Mr. Director, I have an indication the gentleman is going to challenge the admissibility. When can we fix this date for hearing? Because it's nothing to do with the jury. The judge can take an afternoon and say, Mr. Director, bring all the police officers you have, and I'm going to do it. The judge rules that it is inadmissible. The director knows he's got to go ahead with his case without it. He rules that it is admissible, and all that happens is the judge then tells the jury that the statement is admitted in evidence, and it is a question of what weight they put on it. And that way you stop people from coming to sit down at court and waste a lot of time. And the last point, Mr. Chairman, is judge-alone cases. No, I forgot this, judge-alone cases. Can you continue to find 7 panels on an ongoing basis to try cases in Barbados? What impact does that have on the economy? The one that people complaining that the workers not coming out.
Yeah.
Therefore, I recommend the Canadian system that judge-alone trials. I don't agree with the magistrates with having these, not with that backlog of 16,000 or whatever it is. Judge-alone trials should follow the Canadian system, where the sentence and the offense is up to, I think Canada is 5 years, but you can do it up to 7 years or something like that. The accused has no right as to whether or not he should be tried by a jury. It is a judge-alone trial. After that, then for more serious offenses, the right should be given to the accused person to decide whether or not he should be tried by a jury. And my experience from sitting as a judge in Bermuda, Court of Appeal judge in Bahamas and Cayman Islands, you would wonder why certain people would want to adopt a judge-alone trial. And my experience showed that it was the more notorious the particular accused was, the more likely he was to ask for a judge-alone trial. If he was a well-known criminal and his reputation was out there for the jury, he preferred trial by a judge. And it's not the easiest thing in the world. Judge-alone trials are very difficult. And as the man on justice said, you've got to give your reason for every single point that you make. Mr. Chairman, that's my contribution.
Thank you very much, Senator. She's from the DPP's office.
Good afternoon, everyone. Joanne Catwell, Office of the Director of Public Prosecutions. However, I'm not talking on behalf of my colleagues. I'm just an innocent bystander, having been transferred to the DPP. These are just some things that I observed that may possibly help with the delay. The first one, I'm all for technology, and Sir Elliott has spoken about that just now. Sometimes we still have some challenges in the court with regards to technology. We have a transcript officer. I mean, we only have one, and what I would say is that the court in which I work in, we work really hard. And sometimes to keep her there from sometimes 8:30 all up, sometimes in some courts, the transcript officers have to be there sometimes to 9:30. Is there some way that technology could be utilized? For instance, we have AI, artificial intelligence. Things can be recorded. My colleagues, my friends are in the process of buying a robot. Can we use a robot that will be able to record certain things? My second point is training in the form of seminars or workshops on technology and other such matters. And at this time, I want to compliment the organizers here today, because I really enjoyed the presentation from Madam Justice Hines on how the criminal cases, or how the criminal setup is in Port of Spain. And I learned a lot from that this afternoon. And thank you for coming and speaking to us about it. And maybe we can have some more training sessions on how we can incorporate what you would have done, Madam Justice, in Trinidad, and bring it over here in Barbados. Quickly moving ahead, specialize our different courts, sir. Can we have different courts that would address, like, let's say right now we're making a priority or prioritizing the murder matters. Can we have courts that would deal with sexual, like the indecent assault cases and the rape? Have another court that would specialize in theft or money laundering? And I believe with that level of organization, that would assist with the backlog. So you won't have the cases or the matters thrown helter-skelter, but with the degree of organization that will help with the backlog and deal with cases productively. Another point I have is nighttime court. When we had the difficulty where in court 4, it wasn't assigned a court, our court started at 1 p.m. And I found that worked better for me as opposed to the morning court. So maybe a suggestion would be to have morning court and also a nighttime court. And that also assists with specialized witnesses as well. Sometimes you have the doctors and we have to call them away from their practice, and sometimes you're stuck up there waiting for a doctor to come. Maybe for those type of witnesses who have to work in the day, maybe a nighttime court would assist, and that I believe can help with the delay as well. We spoke about this already, fast-tracking matters in which persons will want to plead guilty. And I want to move on to this other point where I'm thinking outside the box. Allow for churches, our justice of peace, to adjudicate minor matters. Churches are microcosms of society, and I look around here and we have some pastors in here, and I know pastors have to deal with disciplinary matters, and churches have to deal with sometimes these very same criminal matters at church, and maybe you can utilize the churches to assist with these matters. And even so, you have churches where, I was also thinking of decentralizing court. And you can even use some of the churches, the actual churches, to assist with court cases, whatever the case may be. Another point is to use pastors or other persons, our leaders in society, to help keep tabs on convicted persons. I heard Madam Justice speak about bringing the person back and ensuring that they're okay after they've spent their time. And maybe we can utilize the pastors to keep tabs on these persons instead of having them to come back into the court. Have persons to assist with the case management. My suggestion here, and I agree with Sir Elliott, where he stated having two masters. My suggestion is to have maybe one master in charge of the criminal aspect and 3 criminal deputy registrars. Another suggestion would be, and we spoke about this, I'll just briefly mention it, if we can have a better way of locating accused persons or VCs. I had a matter recently where it was really challenging to find the virtual complainant, and that can also delay the case as well. I'm all for judge-alone trials. I'm all for that. However, if it is that we continue to utilize jury trials, is there a way that we can, well, I'm asking the question, but my suggestion is increase the jury pool. Increase the jury pool. What I would say is that the court in which I work in is a very productive court. I only know about my court, so I'm not I don't know what happens in other courts. So last week we wanted to start 3 trials the Monday, but unfortunately there were insufficient jurors. There were insufficient jurors. So is there a way that we can increase the jury pool to include pastors and leaders and police? I know police can't serve on the jury, but is there a way that, I know it will be a conflict of interest, yes, but is there a way that we can increase it to include leaders of society so that we can have more persons at our disposal if it is that we continue with the jury trials? Another suggestion would be to minimize adjournments. And I might get a little bashed, I might be bashed here, because what I want to say is that from my experience, the adjournments come from my colleagues, from the defense attorneys. And yes, yes, the adjournments all the time, over I've seen it where, really?
You have 2 minutes, Ms.
I have 2 minutes. I'll be finished, sir.
You have
Right.
to, you
So
have 2 minutes.
yes, I've seen various. We may set up a trial, and because my colleague might be assisting in another court, or they might be in another case, they're unable to start the trial, and then that matter is adjourned sometimes 3 to 4 times. So is there a way that we can minimize the adjournments? And having said that, I take the suggestion from Madam Justice Hines, where you had stated that if 3 times the defense attorney, if there's a no-show 3 times, then that matter is allocated to someone else. And I just want to end by stating that we're all in this together. I don't want to blame anyone. It shouldn't be a blame game. We're all actors. We're all slices of the pizza, in this whole pizza together. And I want us to continue to work together to achieve the purpose and to assist in minimizing the backlog. And lastly, to think outside the box. Think of ways that we can minimize the backlog instead of addressing and going back to the same old ways that may not have necessarily worked for us over time, but to think of other ways that we can minimize the backlog. And that's my 2 cents worth, sir.
Thank you very much. Yes, sir, what's your name? Just give us your name, please.
Good afternoon. My name is Len Santwali. I'm a senior forensic scientist with the Forensic Sciences Center.
Now, just before you go, Len, there is one other person there, and there's you. So I'm going to ask you to be, no, you go. I saw you first, so you be second, ma'am.
I could defer.
Yeah, but I want to hear from the police, and then we have to get into summary time. So be very concise. No, you go.
Yes,
you have the right.
I want to make
I see a lot of papers, so I hope you're not reading them all.
No. I'll be short, truly short. For the Criminal Justice Committee, I just want to make this recommendation that you have some management professional who can pull all of the information together and be able to, so that we're not working in silos, that this person is able to critically analyze where the shortcomings and the impact on productivity may lie, and be able to help gel things together. From my standpoint, being at the Forensic Sciences Center and having had the issues that the lab has had, and I know that the Supreme Court also had its problems where you had to be dispersed in different places, and the lab had its problem, even Parliament had its problem. We must really look at building management systems in this country and begin to examine how that impacts on productivity. I know that the discussion here today is a lot of legal talk, but really and truly, you know, the human resource has to be taken care of properly. And if you can count the days, the down days, the time that has been lost because of what happened with the Supreme Court building, what has happened with the Forensic Sciences Center building again, and we have to take care of the personnel. Comprehensive indoor air quality management must be employed. We have to make sure that we take care of the personnel. Like on my part, presentation of biohazardous evidence in court. From time to time, you will realize that we refuse to bring blood samples to court just so to show the name. Sometimes I even wonder, should ILEN not bring the court's evidence into court? But as a scientist, I have to say,
Dangerous.
how do I do that to you all? Because when I'm in the lab, I'm all dressed up from head to toe to deal with some of these things. But yet I go into court and I see a pants and a shirt covered with blood outside of the plastic bag that I brought it in, and I have to warn the court each time that's not good. The court is set up like this building here, which the AC is like 80% recycled air and 20% fresh air. At the lab, which is now being retrofitted, is now meeting the international standard. But yet I bring a dirty thing to court, and it's there with the jury and everybody else. That scares the hell. Sorry, it scares me. So I well, we can have that discussion. Can a photograph suffice for some things? In other words, I can be creative. I would take some nice photographs, bring them. If you want to see them, I would still bring them, but really and truly it's at you to decide as judges. And as far as the police, I just would like a little bit more communication in terms of the evidence and investigation, because not everything may need to be examined. You just bring the thing that's most probative, and we examine it. Maybe you can bring something else later. I know that that's happened in England when I was training. That's how it worked, because they had to pay the lab. So they couldn't bring 15 items to the lab. They picked out the 5 most probative and bring them. We may need to have that discussion with the police at some point in time. And we may most likely, well, I suggest it, I recommend it, that we build a facility for holding biological evidence, because that evidence is the problem coming into my lab environment. Yes, it's dirty, it's forensic evidence. It has blood, vomit, stool, everything on it, and seminal fluid and so on. I examine it, and then sometimes we can't get it back to the police on time, because when I'm looking for that police officer, he's moved from station to station and so on and so forth. So if you had a facility that I can send it back to as soon as I've examined it, and then from there it goes to court, and then it goes into court briefly and come back out, because court is not the HVAC environment to have those things there either. And I have to say that again, I could repeat that. Those things should not be lying around in a court in an AC environment that is not set up for it. Okay? So if we could move ahead on some of those things, we could protect our court environment, our lab environment, and put those things in a special facility that would manage and handle the chain of custody, the refrigeration, and all of that. Thank you very much.
Thank you very much, Mr. Santuari. Thank you very much. There's a lady, ma'am. You identify yourself, please.
I am the Reverend Dr. Cicely Attil Horsford, Chairman of the Barbados Christian Council. I almost said member of the Moravian Church.
But before you start, I just want to remind that we are running a little tight on time, so I should be concise, just like Mr. Santuari.
I am aware of that, sir, and I am one of the persons that's a stickler for time.
Good.
I wish we would have done that all along. My confession. I was told in my training as a pastor, that when someone confesses to me, I keep that confession. I want to know if in the law of Barbados, where I am a component part, as Justice Graves suggested, if I can repeat that confession, and if that confession is admissible in court. I know I was told that whatever was told to me, I keep to myself. Help the individual one way or the other. I just want to know, is it in the laws, and is it acceptable in here? The other area is that, well, the young lady that spoke just before the last speaker suggested that if we can use ministers, pastors in the jury pool, and I think that that's not a good idea, simply because sometimes we have the necessary information and relevant information that would not help in the overall system. Lastly, the church, the school, the society work hand in hand. If not all of us, most of us grew up here in Barbados, where you find the church, the school, and the wider society. And what is taught at one is reinforced so that it can be a part of. I want to recommend that, as was said earlier today, that we, as a society, we have lost some of the values, some of the things that really count. One of my members said to me, we offer Sunday school. Sunday school we offer as a church, but I also want to add that we offer a lot of things. Members of the council, the churches in general, have been in the forefront, and we will continue to be, and we will assist in any way possible so that we can administer the best justice for all. Thank you very much for the opportunity.
Thank you very much, Doctor.
Thank you, Mr. Chairman. My name is Richard Boyce, Commissioner of Police.
Thank you, sir.
I must apologize for being absent from the room when Mr. Graves started his discussion, his talk. But I came in and I would address one or two issues which I heard on my re-entry into the room. And I can say, well, if there's anyone in my delegation who wants to address any of the matters that Mr. Graves spoke to, they can all feel free to come and carry on and have their views shared.
Just bear in mind there's a time constraint.
Now, in terms of Promax, I came in when he was on the aspect of Promax. But first, let me say is that the police service finds itself in a very, very, very particular situation. Firstly, we are the gatekeepers for the criminal justice system. It is the police service that put these persons before the court. It is a blessing and it's a curse. A blessing in the sense that we charge persons and victims of crime feel some level of satisfaction. I heard figures quoted, 16,000 summary matters and other thousands more serious matters. So that is a tremendous amount of work that the police have done over the years. So, and tremendous sacrifices were made to get where we are. Back to what I heard from Mr. Graves, in terms of ProMax, that is something, that is a system which we as a service have embraced. The systems are almost fully set up. Licenses are in place. So I have no quarrels with Mr. Graves or criticism. We are all part and parcel of having the wheels of justice grease as much as possible. So we would push for that so that we can look at the efficiency aspect to assist the criminal justice system. So that is a process which is actively being pursued. So we will continue that. I will assure persons that we would have ProMax up and running and things will run smoothly before the financial year is complete.
Next year.
In terms of the PACE Act, now at part one of our discussion, we discussed PACE. And one of the recommendations that was made is that we will set up a committee, look at PACE Act, and see how we can embrace it within our jurisdiction. The heads are meeting to have PACE Act Barbados style, Barbados environment working. So that too is in progress, and that is being addressed.
Are you looking at the act of itself or the schedules or the codes? The codes?
The act and all the accompanying things that supports it. Now, he made mention of our Evidence Act. We are moving firmly into the technology age. I too am of the opinion that the current Evidence Act needs to be revisited because there's aspects of that act in terms of how we would like to see tape recordings done, what is shared to the defense. The current Evidence Act does not cover a smooth transition from interview, recording, and sharing with defense counsel. It needs to be updated, and no doubt that is a process that will be given attention going forward. In terms of interview rooms.
Just let me ask a question. Have you ever submitted to Sir David's commission the police's views of the areas of amendment of the Evidence Act?
Not yet, Chair.
Okay.
We are having discussions currently in our department,
Okay.
and that will be, in fact, I met with Sir David quite recently, and we discussed those issues. And we have identified some person who will work with the commission in terms of addressing those issues. So that is a work in progress also.
Okay, thank you.
In terms of the interview room, we have problems with the interview room, and our last discussion with the Attorney General's office and the Prime Minister, we have identified 3 locations which will be constructed, soundproof. And Justice Graves mentioned cannot see everyone in the room. Those considerations will be looked at, and with the constructions of the new interview rooms will be modernized, and the things that we identified as problematic will be addressed. So that too is being looked at. the backlog in cases. We must admit, yes, that there are some matters which we are very tardy in getting before the court. There's a system which is being put in place. We have identified ways where we can address that situation. We are looking to have a pool of officers plus attorneys at law who will look at those files, vet those files, and their tasks will be specifically to call for all of those criminal matters, go through them, and speed up the process of having those files before the court. So the problems were identified and steps are being made to deal with that situation. Mind you, there are hundreds of cases that need to get into the court. So it will take some time. But in the meantime, we are making sure that there's no court in this island that can turn up in the day and say they don't have no files whatsoever to work with. The files are there, multiple files, hundreds of files are there. So there will be no scarcity of tools to work with. It is all there. And those are the things which I heard mentioned by Justice Graves. I don't know if anyone else from my team who wants to speak to those matters which were discussed in my absence. Thank you, Chair.
Thank you very much, Commissioner. Yes, so Andrew, since you were on your hoof, I will allow it. Just let him go, he's there.
Chair, I'm going to be extremely brief, 10 seconds. I think that this point needs to come from me,
Yes.
and I know it may not come from anybody else present as currently constituted. It is that these 7 judges in the High Court are working hard. I don't want us to go away feeling that they are the fly in the ointment. I think it's important that that be said. This group is working from early in the morning till late in the evening and trying to do 3 and 4 trials sometimes. I don't always agree with that. I don't always agree with them, but they are working hard. And I think that needs to be said.
Thank you, Counsel.
Good evening, everyone. Good evening, Chair.
Larry, time is tight, huh?
Yes.
Yes.
Just briefly, I think we can't address criminal justice reform unless we address the socio-economic issues of the country. I think fundamentally, we are addressing the issues at the end of the process. I think the closest I heard is Madam Justice Hines in the case of the juvenile. No, those of you who know me know I'm a proud Wesley Hall boy. No, going to school in town, seeing people from the deprived areas of the society, Orleans, Chapman Lane, Bank Hall, Bush Hall, Eagle Hall, etc. You sit in a classroom with those people and you're not having the same education because they have not had breakfast in the morning. I might have eaten, so they are not learning until after milk and biscuits. So we are wasting time. When they have lunch, there's nothing they're eating when they go home. So doing homework, that's a waste of time. So fundamentally, the issue is one where if we address the issues at the people's felt needs when they're 3, 4, 5, 6, 7, 8, 9, 10, then the police might have less work to do. The judges may have less work to do. The registry system may have less work to do. So we're spending money at the back end as opposed to spending our money at the front end and dealing with those core needs. So really and truly, in a sense, to quote the Prime Minister using the words of my late friend, Mr. Boo Husbands, this, in a sense, is a lot of long talk because we have not dealt with the issue. My father, who taught at Wesley Hall for over 30 years, used to say, as teachers, they could have said, he can Glenderry. Nah, he can be a problem. So the issue really is, we are not addressing the criminal justice issues at the earliest possible stage. And unless whatever comes out of this is the children at Wesley Hall Infant School or at Charles F. Broome or at what other schools in town. At that time it was Robert Boys, etc., St. Mary's or St. Christopher up by Silver Hill and Gall Hill and Chalky Mount Composite. Unless you're doing that, let's shut it down now and let us continue as we are.
Thank you, Larry. Now, I have to move to the point where I get my summaries and give one other person, because we have a 5 o'clock, I suspect, cut-off time, and it's getting close there.
Good afternoon. Mr. Chairman, I'm Trevor Blackman, a member of the Barbados Police Service, and I am the officer who presently has responsibility for the Court Prosecutor's Department. I've sat and I've listened, and I've heard our Commissioner take responsibility for the delay as it relates to the Barbados Police Service. Unfortunately, I have not heard many of the other agencies take responsibility for their part in relation to this system. There was a woman in the Bible, sir, who was caught in adultery and brought before Jesus by her accusers. They questioned him to hear what he would say, but he bent down as though he did not hear them and wrote on the ground with his finger. When they pressed him further, he looked up and he said to them, "He that is without sin among you, let him first cast a stone at her." After a while, he got up and he said to the woman, "Where are your accusers?" And she said, "I have none." He then said to her, "Neither do I condemn thee. Go and sin no more." The Barbados Police Service I have served, sir, for over 40 years was that woman on the 5th of April when this symposium first started, and today. The criminal justice system over the years have undergone many changes, and I believe that in order to achieve the objectives of this symposium, we must look at what has been efficient and effective and what has not, what needs to change, what can be maintained. To this end, I've identified a number of recommendations that I believe can assist this meeting in reaching its objectives. The Barbados Police Service is charged with the following: the maintenance of law and order, preservation of peace, the protection of life and property, the prevention and detection of crime, and the enforcement of all laws and regulations with which it is charged. This requires at times arresting and charging offenders, some of whom are remanded and others granted bail by the court. In dealing with these offenders, it is recommended that the cases be classified and prioritized as categorized. A, accused persons remanded that wants to plead guilty at high court as well as at magistrates' courts. B, accused persons charged with firearm and firearm-related offenses that are on remand. C, accused persons charged for murder and other serious offenses and are on remand, and some due to previous crimes for which bail was granted and they have reoffended or for another reason, as well as cases where accused are charged for offenses against juveniles, bearing in mind the age of the juvenile at the time of the offense and the changes that occur as they get older. I've identified as it relates to category A and B, and this, sir, would have resulted from a previous consultation that was at that time headed by Sir David Simmons, and that those matters should be completed within, matters of that category, within 90 days, considering the nature of the matter where some analysis or some other examination, in order to mitigate any change of place so that there's no undue delay. And I say that because of the fact that there are times when accused indicate that they want to plead guilty, and when they get to the High Court, there's a change of plea. And as a result, the DPP's office is not in possession of any information where they can readily start the process in terms of moving forward with that case. With regards to the summary matters, my recommendation is 28 days, having all the information that the court may require. Matters in category C, I've indicated that those should be addressed within timelines set and progress reports given at 28-day intervals. And this is to the court for a completion time of 180 days. And if not completed, any extension that should be granted by the court after a status report has been given and completion time identified. And that has to do with the indictable cases. Some of those matters are complex in nature and at times require the assistance of external agencies where the process goes beyond that of the Barbados Police Service. Matters under Category D should also be treated as those as identified pertaining to Category C. The other matters where accused are on bail should be completed within a time frame set for such matters to be completed, and indictable matters, the time frame 180 days, and summary matters, that's 6 months, and summary matters 90 days, which is 3 months. I further indicate, sir, that the Barbados Police Service investigates from the nuisance of loud music, the traffic violation, to the capital offense of murder. Our Prime Minister has made reference to ADR, and I therefore make the following recommendations. That an amendment to the Magistrates Court Act to provide a schedule of offenses that can be addressed through ADR to relieve the police of having that responsibility to investigate and charge persons for such matters, but which can allow for the facilitation of those matters being treated through a legal process. Example of such matters, assault and other matters of dishonest conduct, where the value of the property is set at a certain amount. And I say set at a certain amount because at the moment, our Magistrate Court Act makes provision for the magistrate to try theft matters and take a plea where the value is $1,500. Above $1,500, the matter is considered to be a hybrid matter, but there is no tariff in relation to the magistrate taking a plea relative to that hybrid matter. And I believe that a sum needs to be identified where, as I've heard in terms of what Justice Graves would have recommended pertaining to giving the magistrates more responsibility, it means therefore that the sums that ought to be triable by the magistrate needs to increase, and hence a determination would be made in relation to that sum relative to those matters that can be dealt with through ADR accordingly. Exhibits such as firearms and ammunition. I believe that the time is right for the use of photographs to be produced to the court as against having to take firearms and ammunition. And I heard Mr. Centrale spoke about biohazard evidence. I beg to differ in relation to his recommendation in terms of a building. I believe that after analysis that they should be photographed in relation to whatever marks have been placed in position for identification, and the photograph produced, and whatever item it is, that it be disposed of, that it be destroyed. I think taking that item into a courtroom exposes the persons who are in that courtroom to such. As it relates, sir, to the also traffic offenses that the police has to deal with on a daily basis. And I believe the time has come where, as it relates to those matters, that a ticketing system is put in place where the other police officers that are required in the background, because many people may not understand what happens when a person is reported for a traffic offense. That officer who does the reporting, he goes back to the station and he has to record that information. Then it requires someone else to write an information on a summons. And it requires another person to review the application, which is a supervisor. And then from there, it goes to another senior officer. And then from there, it goes to another department before it gets to the court prosecutors department. And then when it gets to the court prosecutors department, it still has to be documented there before going to the clerk of the court, who also has to record that information before passing the information and the summons to a marshal, who is going to come back and say, accused not found.
Officer Blackman don't want to run you because they have some interesting points.
I think,
you have
sir,
here, but
that
just hit them with bullets so they can take them. Do them bullet in bullet fashion. Your points. So how many more points you have there? You have the exhibits, the traffic offenses, ADR, amendment to the Magistrates Courts Act. I have a time constraint. That's my problem. So I want to hear you. So I'm asking you to hit me in bullet form.
Yeah. I want to comment, sir, on two last points.
I'm not stopping you. No. I just ask you to do it very quickly.
I can make my presentation, sir, available because I have it in writing so that I can submit it. In addition, sir, the committal proceedings, I must comment on those because I believe that the legislation or the framework is there in relation to committal proceedings, and that as it relates to the sufficiency of the evidence, that responsibility rests with the magistrate who has the jurisdiction to address that matter. The problem, however, is that I think to remedy the situation until some other means or method is put in place is that there's a need for a timeline pertaining to how many adjournments is going to be granted for someone to make a submission in relation to whether there's a no-case submission, how long does it take? Because when one looks at delay within the system, there are occasions where...
Mr. Blackman, I don't want to interrupt. What I'm telling you, rather than giving commentary, just make your points. Bram, so you can make a list of them.
Yes, sir.
So don't editorialize on Julie. Just give us the points.
Right. So I'm asking, sir, for there to be a timeline set in relation to moving forward, relative to how long. Adjournments, that there needs to be a timeline set within that's the magistrate's court system where the police prosecutors operate. Because in the absence of such, then delays will continue. Thank you, sir, for your...
But I'm sure you have some other points you said.
No, that's it, sir.
You're sure?
Yes.
Okay. Now, we have reached the point where apparently there are some time constraints when we have to, I am told, that's correct, Dale, vacate this building. There's no time, there's no run over time. Okay, so we're at the point where we now have to have some takeaways in terms of recommendations, which have to be sent on to the executive so that where legislative steps have to be initiated, you can start to address them. Sarah, you want to roll the ball a little there in that regard? I think you've heard quite a bit this afternoon. Church, DeSantis, others.
So now we're talking about implementation. What can we do that is going to make an impact in changing the criminal justice system in Barbados? One suggestion is to set up a criminal justice committee. What that would do is ensure implementation of many of the recommendations that have been suggested over the past 2 days. That would be a committee with heads of department, including the Bar Association, the DPP's office, the Commissioner of Police, the Superintendent of Prisons, the Chief Justice, the Commissioner of Police. Those that are fundamentally, and I say fundamentally, obviously everyone here is involved, but fundamentally involved day to day in the criminal justice system. Does anyone have any views or any opposition to setting up a criminal justice committee. Can I just say it has been done in St. Kitts and Nevis and was highly successful in helping reduce their backlog.
And I can add that there is a committee in Trinidad chaired by the Chief Justice, a multi-sectoral committee of this very nature. In Trinidad, it exists now.
Sir David. How often would you suggest? So everyone in favour for a criminal justice committee?
It cannot be a talk shop case.
No,
That's
the objective is to implement.
Yeah, we're going past talking.
Okay, so there we go, number one. Number two, public and witness.
Hold a minute. Do we have then emerging a consensus that there's need for the Criminal Justice Committee?
Yeah.
Okay, thank you very much.
Provisionally, just looking at how it operates across the world, it would involve the DPP's office, the Commissioner of Police, the head of prisons, the head of probation, the Attorney General, the Chief Justice, the Bar Association. But obviously that is subject to discussion. What is important is that there is a committee whose role is to implement criminal justice reform in the country. I'm not saying that, I don't know which department you're from, I'm not saying that you shouldn't be included in it, and depending on the topic, what some criminal justice committees have done is bring in externals when they are discussing topics that are relevant in another, sorry, go ahead.
Good evening. My name is Cheryl Willoughby. I'm the director at the Criminal Justice Research and Planning Unit. I would recommend that, in addition to the committee, that research play an integral role on that committee. It's important that as decisions are made, they are based on sound evidence, based on research. I think that was the reason why Sir David would have set up the department over 18, 20 years ago. And so it's important that research play an integral role in the decision-making process within the criminal justice system. In the absence of that, we will continue to make decisions based on anecdotal information and how we feel personally about how the system should be run. That's my recommendation.
Yeah, no, I completely agree with you. And obviously the Attorney General would sit on the committee, and the Criminal Justice Planning Unit, as I understand, comes under, forgive me, I'm an outsider, but my understanding is it comes under the Attorney General and therefore
Most
automatically
definitely.
would
Yes.
feed in.
Thank you.
Criminal Justice Committee, consensus. Number two.
Can I suggest the public and witness presentation from the Bar Association in terms of trying to start now? There is already agreement in terms of putting information on websites for victims and witnesses and the general public to know about the criminal justice system. We have already prepared some material about what happens if you're a child and need to go to court, or if you are a parent of a child needing to go to court, or you are a victim and witness. Can I ask which organisations would be willing to put this information on their websites?
Well, I think that was given already.
Sorry,
Minister
the Bar
Abrams.
Association, the
Yeah.
Men's Empowerment,
Minister Abrams said earlier this morning, GIS, yeah.
GIS, the police, the court.
Mm-hmm.
That is an automatic big win for the public in terms of learning about how the criminal justice system works. Sorry, go ahead.
Yes, hi, good evening. I'm Nariba Daniel. I'm here with the group representing the Barbados Association of Professional Social Workers.
Mhm.
So on this topic, I think we can help as well, because social workers do, and especially even listening to what happens in Trinidad, they're kind of light years ahead in certain areas. So I think that this type of symposium has shown that social workers can play a greater role in the criminal justice reform, especially as was suggested that we do have to start looking at what's happening in the communities and trying to tackle things earlier. So
yeah, I completely agree. You play a fundamental role. Do you have a website that we could put this information on?
Yes,
We can also.
we're trying to build on different pillars. So I think that if I will tell the president she had to leave early, to just reach out so that we can also help in this area. Because just to go away with this quick point, I do realize, even funny enough, as in part one, as soon as things get juicy, we are about to conclude. But when you really think about it, this is a room of degrees, of experience, and of titles. And I think everyone has enough experience who worked in the justice system, social care, to know things that can build. Trinidad is not that far away, and as was said, everybody could look at a phone and see how other things are run. But I think we tend to forget the cultural point that we don't like to admit. We have a culture of pointing, and everybody has an issue with their department, but we need to come to a point where this is Symposium Part 2, but we need to get to a point 3 where the action comes. We tend to always say, you do you, change. You do that, change. But who's going to take the step to actually come together? We don't like change. Let's be real with that. So we need to do something. We need to start to let go egos, let go likes, and just start doing things. I would like to acknowledge the Men's Empowerment, because they did have a program recently for young boys. And I think that we all, even speaking about the Social Work Association, we need to also do more. So
thank you so much. Thank you. We'll make sure that you have all the materials so that you can also play your part. Yeah, and will obviously be co-opted when needed onto the Criminal Justice Committee. Criminal procedure rules is another big one. Is there any opposition to the introduction of criminal procedure rules? Obviously, we haven't seen them yet, and they require public consultation. But as a concept, is there any opposition? Good. I think once we've got a draft, that can be circulated to the relevant parties. PACE, codes of practice. Any opposition in relation to the police having codes of practice and the way they conduct their investigations? In fact, maybe support, I should say. Support for that.
There are no dissentient voices.
Digital recording of suspect interviews, both audio and video. We have seen across the world this is has made a huge impact, and in many jurisdictions has completely got rid of voir dires, which means an instant reduction in delay. Any comments or objections to the expansion of the use of digital recording of suspect interviews?
Nope, no objections. We can go ahead, number 6.
Support for that? Yeah. There are obviously many legislative provisions that have been suggested. Can I make a suggestion that all those who have any edits to legislation that should be done, that they send those to the Law Commission, who can then consider them each and every one and see where those amendments can be made?
Largely to the Evidence Act. Yeah, we'll come around to that in a minute. Hold a minute, Larry. Hold a minute. We'll come around to that in a minute, but it was just this principle, the Evidence Act, based on Sir David's presentation and some of the strictures that were directed at it from some others. No, we're just talking about some amendments, I would say, principally to the Evidence Act, rather in the terms of what Sir David suggested, and there were some additional strictures that were leveled at it from some other presentations. So I think that's the big one, the evidence amendment.
Yes, I mean, I think any amendments, legislative amendments, probably we would need to look at in a written form, unless anyone has anything specific that they would like to raise at this forum.
I know I'm the real outsider, but I don't know how the room feels about legislation to establish plea bargaining, structured plea bargaining, and judge-alone trials. Not amendments, but actual legislation. How the room
those are some of
feels
the
about
subheadings. Those are some of the subheadings.
Should we start with judge-alone trials? Are there any objections to judge-alone trials? Yeah. Go ahead.
Until everything is clearly in place so that the selection of judges is entirely transparent, I don't think we should move there. Right now it is transparent in the sense that we do it without the legislation in place, as I understand it. We do it in the honorable way, but as far as I'm aware, the legislation that secures the once it's in the law, it's comfortable. Once you're all happy that the judges are being selected without the usual reliance on good practice, I'm cool.
Yeah. That's a narrow point of objection, Billy.
I thought I should just clarify that since 2019, the Supreme Court of Judicature Act was amended to provide for the establishment of the Judicial Appointments Committee, which I have the honor to chair. And that committee advertises vacancies and conducts interviews in respect of the appointment of judges under Section 81 of the Constitution. There is another provision in the Constitution that allows, so when we had, Andrew, when we had the last set of appointments, about 5 or 6 judges, we advertised in all 56 countries of the Commonwealth, and we were assisted by Commonwealth Judges and Magistrates Association, CCJ, all kinds of people. It had wide publicity. We got a large number of applicants, and we were able to do the interviews, and the appointments were made. But there's another provision that allows the Chief Justice to make representation to the Prime Minister that the business of the court needs to be strengthened by the appointment of temporary judges.
Correct.
Right?
Absolutely.
It's 84, Section 84 or something, not one of them, or 82. So that you have 2 methods now of appointing judges. Permanent judges under Section 81, you come through the Appointments Committee. We make the recommendations to the Prime Minister as to who should be appointed. She gave her assurance in Parliament that she would abide by the recommendations of the committee, and so far she has. And you have the other provision, which I believe has been activated by the present Chief Justice, where he says, well, we are being inundated with criminal cases. I need 2 temporary judges, and so you have 3 or 4 now. But we have no say in that. They're only temporary. They are not for the purposes of Section 81 of the Constitution. Got it? Thank you.
Good, thank you very much. That's great, Sir David. Thank you very much. Yes, quickly. You realize that the AC has gone off? And the signal is...
I guess that's the signal.
Leave soon. It'll start dim the light shortly. Yeah.
If I may, Chairman, the question about judge alone and not judge alone, I don't think sometimes is us and them, because I think this is one that we would differ significantly. This is where talking about the prosecution and the defense.
Yeah.
I think sometimes it's up for the wider society. We've got some members of civil society that may not understand or appreciate the vicissitudes of the trial process and the judge alone and that. You know, I do not like the jury system simply because of the delay, not because of a man's right to be tried by jury. And I see it every day. You need, if it is a criminal trial, a capital matter, you've got 12 members, all have to be in sync. If you've got a non-capital, it is 9. I talk about 9 extra players to the already burdened system. So we come to work on mornings, 1 juror absent, that's a day work. Nothing happens that day. Because the judge is not going to discharge that one man on a simple day, because it might just be some process, he's late, he has a problem with the wife. So nothing happens that day. He has a problem with the wife. Some other reason. He might even be there for a week. But anyway, so you have these problems occurring, I mean, daily. So when you talk about judges leaving early, if a judge is on the bench and a juror comes, a juror is not there for the day, he can't do anything without the jury, so he must as well discharge the rest and let him go. And as Sir Elliot spoke to it, and I agree with him wholeheartedly, it is wasting a lot of time. Some jurors will not go back to work regardless of how the judge tells them. So you get no production in the country that day from them, because once they come to get picked in the jury pool, I see some follow cases for 3 and 4 months in the system. So I think we get problems with them, and I think that's the problem. I do not like the jury system. It does not work well, and there are too many things that can cause it not to work. Prejudicial evidence slipping into the jury pool. I've done trials already. I've gone for 6 weeks, and some prejudicial evidence gets in, and the judge said, this now is fatal to the case. We have to start over. It will not happen in a system where you don't have a jury, because the judge is now fact and law, just as in the magistrate's court. And if persons complain that you're not getting a fair trial because it's a judge alone, then we must say all the magistrate's court trials are unfair. And I don't think that is so. So when I really look at it, I see it as a system that's outdated. That's my opinion. And I think that even if you talk about giving options, I think that's going to be a problem, because people are going to still choose the jury system because it allows them to more or less work the system. And I think the courts, we have to make a decision that, as far as we're concerned, as Mr. Graves might have said, there are certain cases, and we cut a tier that these are going to be judge alone, and there are still other options for certain matters. If you want to call the more murders on things like that, fine. But we can't do it every day, because we waste a lot of time in court. And accused men know that. Sometimes an accused man don't want to be tried by a judge, and there's a lot of back and forth, and then the accused man suddenly says, look, I got 5 cases in front of these. Automatically the judge says, well, the jury pool has heard that you have 5 other matters. We can't hear this matter anymore. A delay. We get delays all the time.
Can I invite you to make these points when you're on the subcommittee? Flesh them out. Yeah, flesh them out, because I want to get some of the head-ins right now. So I understand where you're coming from. But thank you very much. Thank you very much. So we're at plea bargaining. So I understood Mr. Pilgrim's point. Yeah.
Oh.
Yeah, which you withdrew. So I understand what the DPP said, but I think that can be fleshed out in the subcommittee. So could we, the next one, plea bargaining.
Plea bargaining legislation.
To go with the MSI. Yeah.
Yeah. And sentencing guidelines also to complement the MSI.
Yeah, so plea bargaining is agreed with the current MSI maybe to be strengthened, and sentencing guidelines. Were there any other points came from Justice Graves that we need to look at? There was a...
No, I think the police have already started the CROMAT.
Huh? Yeah, the abolition of paper committals, and let there be a sufficiency hearing. One view was that, given the load of the current High Court judges, a sufficiency hearing before them will be difficult. So maybe the suggestion will have to be for certainly another master, at least one, specifically dealing with criminal matters, who will hear case management issues under the new rules, and sufficiency hearings so they can then go on swimmingly to the High Court. That would be my thoughts at this stage, but I'm sure that can be drilled down on. So the use of a master to facilitate sufficiency hearings and case management coming under the new rules. And another one would be the abolition of the paper committals, but that flows from that. Because if you're going to have the sufficiency hearing, you're obviously speaking of abolition of the paper committals. Are there any other ones that anyone can think of? I think, yeah, paper committals, you got it. Yeah. How many you have there, Sarah?
So we've now got 7.
7? 9,
including
yeah, there were
criminal
nine proposals here so far. Is anyone thinking of some?
I think it's already in the works, but the case progression unit in the within the Barbados Police Service will make a huge impact.
Mr. Chairman, I have reason to believe that the PM will fund additional prosecutors to support the police prosecution in the magistrate's court. So I wouldn't want to lose it if she's willing to pay for it.
So maybe we should put it. We should put it in. Well, please have that in the additional prosecutors, prosecution service. If we want to style it that.
And just to clarify, would those lawyers be under the Commissioner of Police or under the DPP?
I suspect under the DPP.
Well, that would be good because I think it gives a little more transparency to the process. Let the police investigate and do all the other things, charge, but let the prosecution be dealt with, hopefully, an independent entity. Right? And that has always been something that lawyers have kept loud noises about. Yeah. Yes, Christine, very quickly, yeah.
Hey, good afternoon, Kristen Turton. I'm just querying whether among the list is the creation of a public defender's office included, and if so, the question of funding obviously would have to be considered, because I do recall one of the recommendations
that was touched upon, yeah.
being mentioned. Yes? Okay.
Yeah, it's definitely a recommendation. I'm looking to the Attorney General in terms of whether he believes the Honourable Prime Minister will fund that as well.
I think it can be placed on the list and to be discussed.
I think that let's put that on the built-in agenda for the committee to work with.
Yeah.
But if you know about the Prime Minister, she's a little parsimonious. So we get some now and some later.
Some later, yeah. Are there any other suggestions that anyone may have?
I think one that was discussed,
Yeah.
even from the Honorable Prime Minister, was a reform of the way children in conflict with law are treated.
Well, I think there's some legislation
So
coming.
general reform.
That's the legislation coming through.
That's before Parliament. This is
Right.
child protection.
Okay, it's there
justice
already,
secretary.
okay.
Yeah. Pili, yeah, I recognize you.
I think one of the main concerns that the bar has had, and it was voiced largely at the first session. I don't think we need to, I wouldn't want us to not address it, is the feeling that like situations with the phone recording a private interview between client and
Oh,
thing,
yeah, that experience.
these things, that and other things like I like to call it the Pirates Cove beatdown, things like that need to be, we need to have a sense that those are being addressed by an entity outside of the police force. And I think that's something that's very important, because much of the other things that we are doing don't address police conduct at all. And maybe that may be for a separate forum, but if not, I think we need a feeling that something is being done to ensure that those investigations are carried out transparently and in a timely fashion, because Barbados is a place in which things like this are front page news the first day, and then they're fish wrapped the next day.
Yeah.
Yes, indeed. I think that the whole purpose of the Criminal Justice Committee is to address national issues. And one of the topics that can be addressed within that committee is the police disciplinary procedure, because obviously that needs to be a transparent thing.
Process.
And there needs to be accountability.
Agreed. I mean, it's topical now. Huh? Our counterparts in Trinidad can tell us how topical it is. Right? These things need answers. We can't have the feeling that our police are free to do the bidding of anybody else, for example. Somebody needs to be willing to come forward and say, we had nothing to do with Brent Thomas. Someone needs to say that.
Just for the record, It is sub judice in my country right now. It matters before the Court of Appeals. So
Understood.
I say nothing, yeah.
It ain't something doesn't here. So somebody
But,
need
but
to
not,
take
not,
responsibility.
not looking at any particular cases, that is a topic that can be part of the discussions of the Criminal Justice Committee.
It's not off. Can we invite the chairman, the substantive chairman back here? Well, I think we have touched most of, we have about 12 or 13 recommendations thus far. And I take this opportunity to invite the substantive chairman back to this position. And I thank you all very much for your participation this afternoon.
Oh, yeah, no, I think that's legislative, isn't it, already?
Hewlin Allman.
Before the hotel turn off the lights, Huey's last role would have been to invite me to say a few closing remarks. That is good for two reasons. One, it saved Huey coming to the podium, and two, it means that I have to be very brief. At the time when we first thought about doing this criminal justice reform symposium, I have to say that there was some initial discomfort, largely because of the fact that we were going to be touching some very difficult and, in many respects, painful subjects, as the Commissioner of Police would attest. But I don't think that any of you would have traded our gathering in April or gathering today for anything. If there's one thing that can be a sore in our side, it would be to allow the criminal justice system to continue as it has been. I think that we've stepped in and proposed to take initiatives, not quite in the nick of time, but certainly in good time. I hope that we'll be able to achieve the various things that we've committed to achieving in a very, very short timeline. I can tell you that the Prime Minister has required of me that all legislation which has to go to Parliament has to be there before the end of July. You know that she's a hard taskmaster. And I think that I'll be able to deliver on those legislative instruments. But as we all know, anybody could pass a law, right? It is how we make those laws work and how we make them relevant to what we have to do. Your participation has been outstanding. There are now a lot of chairs at the back of the room that are empty. But for those people who've left and for those who are still here, let me thank you for supporting this process. Our commitment, though, will be proven by the things that we're able to deliver over the next few months. There are going to be other symposia. There are going to be discussions on criminal justice. And Madam Justice Ramprasad Hines, thank you for agreeing to come back. Should your Chief Justice agree that you can come back. And the Caribbean Court of Justice has reached out to me only last week to say that they too want to have their education academy, wants us to host a regional symposium on criminal justice reform. The issue is topical, but for us the issue is more than topical, it is real. And we have a whole country and its safety riding on our success and on our commitment. Let me thank you very much for your support. Let me especially thank our two stalwarts, Sir Elliot and Sir David. They've been here with us from the beginning, and it is good to see two doughty campaigners still staying connected. I didn't. You've both represented yourselves very well, and I don't think that doting would even come into anybody's mind. Let me thank you for staying connected. Let me thank you, Commissioner. I know that it has been a tough journey for you and your members, but we know that you're committed. Let me thank the bar, without whom I don't think any of this will be meaningful. Civil society has been very patient, and many representatives of religious bodies have taken the time to come and sit with us over the last, over this session and the last one. I know that sometimes what we have discussed may appear to be a little bit mystifying. In fact, sometimes downright confusing. But I hope that your participation will not just be for these last 2 days, but that you will stand in the trenches with us as we work towards a better Barbados. I don't think I've left out anyone, but if I have, please know. I thought I did say the Bar Association, not the bar, right? The DPP and his fine staff. Andrew Pilgrim said that the judges are working really hard. And it's like cricket. They couldn't work really hard unless you were also working really hard. So let me thank you for your efforts in this regard. Ladies and gentlemen, I think you must now leave this place. And I urge you to do so. There are no refreshments outside, but the bar is always open.
It's very exciting.
You know, like the priest who marries the couple, you now stick around and
Make sure they carry on their journey. Yes. Yeah, yeah.
So at least
Yeah, no, it's amazing. It's amazing. Definitely related. Definitely.
next ever symposium. Next ever symposium.
Yeah.
Really? I'm pleased with it.
So when do you want me to have the first
Well, I'm going to confirm with membership, and I'm covering just need to confirm with the chief. I don't know, the Prime Minister and the current cabinet hate the idea of rolling with the numbers were the Bar Association. There's no, they're not listening. They actually need to select individuals from the intervening
with the deputy?
say you
And then it's just working out what's the first topic that's going to be. And maybe it should be. How do these disciplines
That's understandable.
Yeah.
But I want it to be monitoring these things. Much of that is
But I think, yeah, I mean,
yeah, of course.
Okay. You've got, yeah, I didn't know. 262 here.
Okay. Judge, I know that you did not plan on spending your money in this place.
No, but that's why I came.
You probably had a little bit extended.
No. And this is why I'm here. This is why I'm here. And it was a day well spent. Yeah, that's well spent. And I'll be happy to want to encourage you.
Well,
to commit myself
listen,
to help with training.
I've already spoken to the DTP and have the cabinet Nicole, thought you were leaving. Come and meet the judge because you met the judge. You met the judge. Come meet the judge. Nicole Thompson is my special advisor. Every attorney general has a special advisor. This is my second thing. This is her second thing.
I see.
So this is Mark. Anyway, this is the judge. This is the judge.
I know. I watched her in Trinidad.
Oh, yeah. No,
I watched
couldn't
her
come.
from home.
Oh, I see.
Because it was
Yes, yes,
streamed.
yes.
Your presentation was brilliant.
Yeah, I didn't know the.
She didn't like the others, but
I-
yours were great.
Yeah, but I'm prepared to work with you on it because I'm telling you, plea bargaining is the way out of a bag.
Listen, I'll arrange for you to come back up. We're going to get this legislation in place quickly, but then obviously the judges are going to need time to read it, so maybe I can get you and Sarah, judges and everybody.
They are the ones, the plea bargaining, they are the ones who are going to do it. Yeah, the judge doesn't really get too involved until
okay.
the end.
Well, I suppose.
Yeah.
Well, yes, there's no need to go out.
Well, most definitely, yeah. But it was a pleasure. Definitely, I'm happy. I'm glad I came and we made it happen.
And I'm glad it related.
Did I?
Get my email.
Which one was
I
yours
sent
again?
you 2 emails, Rob, and
Oh yeah, I got everything.
Oh,
I read all of that. I had it printed out and ready. That's what made me try to tailor what I was saying to fit what was said previously. Yeah. So thank you very much.
And if
Now
you
I
have a
have your
written
email.
presentation that you can
I'm
email
going to
us.
reduce what
Yeah,
I said
know
today
what
into some
I know
bullet
what that's
points.
like. I
Yeah.
know what that's like.
No, but some bullet points because the rapporteur said that she had a hard time keeping up with my pace.
Between the accents.
Yeah, and I was talking too fast, so she wants me to
Have
reduce
you
it.
met Sir Motley?
We were introduced earlier today. Yes.
He's related to the Prime Minister.
In some way, I understand. In some way, I understand.
You know Wendell Motley?
I can't say that I know him personally. That's the way I'll say it. Yeah.
I spoke to Reggie last week. Reggie,
Oh, yeah.
he's telling me that he was introducing a bill into Parliament to abolish polygamy.
Yes, Ajipa. Yeah, it's a serious piece of legislation. Radically going to transform that system.
Yeah, but he said he promised no one to introduce into Parliament. But most of the places have it, Turks and Caicos.
Yeah, sufficiency hearings, but what they're trying to do is fix some very rigid timelines, which the DBP has been objecting to.
But you see, I was a court of appeal judge from 1999, president of the Belize Court of Appeal, president at the end of the last 5 years of the Turks Court of Appeal. I served 10 years of the Training Court. I wrote a judgment to the one in Turks.
Yeah.
Because I had to write.
Leave some flexibility.
Turks had shall, but Turks is not mandatory.
I see.
I held that it was directly only.
Right.
Did not initiate the conviction. So the fellow was saying that it didn't supply him the things within the time limit.
Right.
Insufficiency hearing was convicted.
I'm going to look for that. What's the name of it, though? But I will look for it.
The Turks and Caicos.
And you did it. I will look for it.
And I also did. I did a judgment. I can tell you this one. Malik Cox, which I wrote a judgment on the duties of the judge sitting in the room.
I will check it out.
I went to Privy Council with dismissal. That was not an issue. What I said in the case was not an issue with Privy Council. Malik Cox.
I will look for it.
It's the
yeah.
end of last year.
All right, okay.
Or early this year. But
All
the case
right.
was last year.
All right, good. Well, then you want to
It's good, it's free money, isn't it? It's easy money. We'll find a bigger job, dude. No. Peter, about maybe 10 million. 10 million to the United. Thanks ever so much. Yeah, I'll see you next time. All you do is get back.
Sir. My little boy had issues with him nervous here. You know it's all right. Thank you. Will you need to get Nicole? You know what? Ask this time.
Yeah.